Yes, sir.
Melody, item number 5.
Item number 5.
5 Melody.
Yes, sir.
It has come from the mediation, Melody. It could not be resolved here. So may I pray for fixing it on next Tuesday, Melody, for hearing, Melody.
Oh, yes. Next Tuesday. What's a gap?
Right.
Next Tuesday would be 10th. Mr. D. Chaudhary, the senior advocate, has submitted that the mediation in the matter has failed, and therefore the matter may be taken up for adjudication. List on the 10th of February at his request, and with the consent for the learned counsel for the respondents. Much.
May I please, Lord?
Yes,
I'd like to mention item number 51, that is a fixed matter. Last Wednesday it was listed and the last hour is taken out. It is requested accordingly today matter is fixed. May I pray for, can it be at 2, Malot? There's an urgency, small issue, Malot, that is why.
Okay.
Highly blessed, Malot.
If it does not reach before 2, we'll take it up at 2.
Right.
Yes, sir.
That is it. I'd like to mention item number 31.
31.
I have instruction to withdraw this content.
Withdraw.
Withdraw.
Mr. Adhar, learned counsel appearing for the petitioner, has submitted that he is under instructions not to press the petition in its present form. Accordingly, he may be allowed to withdraw the contempt petition. Stop. Contempt petition is withdrawn as not pressed.
Nice.
You are appearing the matter?
No.
Yes.
Wait, please, Lordship. I'd like to mention item 44.
44.
Lordship will kindly accommodate for the day, my lord. Lordship can take up, if not inconvenient, tomorrow, my lord. Yesterday, there is a death in my family, my lord. I could not do.
Although the matter is of 2016, the request of the learned counsel for the petitioner, which is not opposed to by the learned counsel
Have informed.
for the respondents, list this matter again on, give us a date, sir.
Lordship, isn't the convenient, my lord? If
You are
tomorrow
copy-
also, I have no difficulty. Or on 12th, my lord, Thursday.
12th, we have fixed many cases which we will try to dispose of.
My lord.
19 or 18?
19, my lord.
19th.
19th.
On 19th of February 2026.
Grateful, my lord.
Item number 8, Lordship. I have taken. Yes, Lordship. Therefore, only today accommodation, my lord. There's some difficulty. I have taken something from data center.
Post list এখনত তেওঁ লিখিত হৈছিলে কিন্তু পিছত anyway, at the request of the learned counsel for the petitioner and the consent of the learned counsel for the respondent, list this matter again. Is there any urgency in the matter on either side? No. Then we'll take it up on the 23rd of February.
Deeply blessed.
Yes.
May I please, Lordship? Sir, I beg to mention item number 16.
16.
16. My lord,
Yes.
Yes, I to kindly adjourn for 2 weeks. Actually, my brother expired due to which I could not prepare the case. Actually, I have informed the other side.
You are appearing for
For the respondent number 2 and 4.
at the request of the learned counsel appearing for the respondent number 2 and 4. And on a statement that the other counsels in the matter has been informed.
Yes, ma'am.
List this matter again on
3rd of February, if it possible, ma'am. Any date.
February
Yes.
20th, 20.
20. Oblige.
Your Lordship, may I please beg to mention item 50? The matter has become infectious, so
50.
yes, Your Lordship.
Learned
The matter has
counsel,
become infectious, so may I
Learned
please
Counsel-
beg to withdraw.
learned counsel appearing for the petitioner, you are Mr.
KG Chaudhary,
appearing for.
JMA Chaudhary, Your Lordship.
Chaudhary has submitted that the matter does not require further adjudication as it has become infectious. Full stop. Accordingly, the writ petition is closed as infectious.
Deeply obliged.
Yes. May I please, Your Lordship? Lordship, I beg for listing of a writ petition. Lordship, it was not listed as per the previous order.
I think there are senior benches for this. Number one, if we had fixed a date, kindly give a copy of the order to the registry if it was fixed for today. It will come up at 2 o'clock. The code you go. Fixed asile has to. Oh, that's on. Itu niki kali je goisile. Just a minute. এইটো কাগজখন লৈ পেলাই সুধি লওক কালি হেৰি আহিছিলে যে লিষ্টিঙৰ মানুহজন যে আহিছিলে কিবা এটা পুৰণা ফাইলটো বিচাৰি পোৱা নাই, disposed of কেইটা, it is this one. Oh, that has been withdrawn. এইটো চাবচোন তেতিয়াহ'লে আজি ফিক্স আছিল বোলে।
Please, Your Lordship. So I beg to mention item number 26, Lordship.
26, yes, sir.
We are seeking 2 weeks' time to file a reply, Lordship. Affidavit in opposition was filed on 21/1/2026, Lordship.
Learned Counsel appearing for the petitioner has sought accommodation for 2 weeks
2 weeks, Lordship.
to file the affidavit in reply. List again on pick a date.
Can it be on 23, Lordship?
Yes, 23rd of February 2026, along with the reply proposed to be filed.
Hello, Lordship.
May I have?
Yes, sir.
Your Lordship. This is 483 application, my lord. Charge seated matter, my lord. Charge seated matter, my lord. Annexure D, page 32, my lord. When charge sheet was laid, my lord, we have approached the lower court below, my lord. So matter has come here, my lord.
What was the allegation?
POXO, my lord.
POXO is given as now notice and
Notice and
TCR.
TCR.
Notice and TCR.
Mr. So-and-so, Learned Counsel appearing for the petitioner, Mr. APP. Call for the trial court records, notice to the respondent number 2 as per the notification. List again on 18th of February 2026.
Obligation.
Please, one. This is a matter where I was in service of ONGC and there was an order of dismissal without any superannuation benefits.
Okay.
But there is also an underlying CBI proceeding.
Would the mediation help?
But the only difficulty is that there is because of the same allegations, there was an FIR registered with CBI. CBI FIR has today proceeded. There is a charge sheet which is filed and the trial has commenced before the CBI court. On the aspect of whether my dismissal was right or wrong, maybe mediation, but otherwise there is a criminal angle to the entire.
Will we, if that be so, we cannot interfere in the
That would be a
petition.
difficulty, my lord, in sending it to mediation because there is an underlying
We'll keep it as not agreed and we'll take it up.
non-starter or something. Because otherwise my instructions are to go into mediation, but because of the pending
If
CBI.
the client says so, have an attempt.
Item 48, Niki.
Why take it on your shoulders?
I'm sorry, madam.
If the client wants it to be sent to mediation, why do you take it on your shoulders?
So I'm only as an officer of the court pointing out that there is an underlying.
I understand. Let the mediation report come. That would be the best part.
I'm for ONGC, my lord.
No, he says that there is an angle of a criminal case.
Yes,
So
the
mediation
trial
is
is going on.
mediation may not work. But if the client says that he wants the matter to
So
be
far,
referred,
ONGC is concerned, I don't have that instruction whether
we'll say
ultimately, my lord, the allegations are very serious.
we'll say agreed to put it before the mediation. Let the same fail. We'll take it up for adjudication. Because we cannot overlook the petitioner's request to him to send it for mediation.
And the problem is in the writ petition, we have also issued the question of jurisdiction because
Everything, we'll just send it to mediation. It doesn't work. The mediation anyway, it can take place. It's a
keeping in
mediation
mind,
for the nation.
my lord, keeping in mind the allegations and the criminal
But
case
the
pending.
parties are not agreed to as not agreed to query list for admission on 26th of February 2026.
My lord,
I'm good.
I'm for ONGC, my lord.
Format of DD1 not agreed to or not agreed to list on 26
But
February.
ONGC is not agreeing to because parties not agreeing to would even mean that
Okay,
we not agreeing.
then you cut off the.
Lordship may put it on ONGC, my lord.
Huh?
Lordship may put it on ONGC. That ONGC, first of all, I don't have the instructions and keeping in mind the allegation and the pending CBI case. So
List the
perhaps
list the matter again on 17th of February where both the Learned Counsel for the parties shall contact their clients to have appropriate instructions whether the matter can be referred to mediation or not.
can it be on 18th, my lord?
18th of February.
18th.
I'm good.
Huh? Amar agote ahibo. Please have your instructions.
My presence may be required.
Councillor presence সদায় লিখিব না গোটেই কিজনৰ Even noted. Yes.
May I please your lordship? Lordship, in this matter, lordship, the petitioner was engaged as an assistant executive engineer in the GMDA. Thereafter, as a superintending engineer on a basis of a contract of the year 2015 and thereafter renewed from time to time. Now, lordship, though the petitioner has retired, but lordship, the petitioner was entitled as per the contract. Petitioner was paid a salary and other benefits as per the rules of pay 2010. Lordship, after implementation of the rules of pay 2017, lordship, the increments were increased as per 2017 ROP. But thereafter, after a few months, it again came down to ROP 2010. There, lordship, the issue was raised before the authorities. Then the authorities asked further directed that a comprehensive proposal regarding this issue be placed as regards the petitioner. However, nothing was done. Lordship, therefore we approached this honorable court, lordship, because he had an expectation that the salary be increased as per the ROP 2017.
You had an earlier round of litigation.
Earlier round, lordship, regarding regularization, lordship.
Yes, can you deny him that pay which you once started him?
I have received my instruction, my lord. What has happened, my lord? This is a contractual employee. Contractual employee. Contractual means that he's seeking the 2017 ROP should be implemented. Contractual employee cannot be granted. That's the instruction, my lord. I will file an affidavit.
From where is it said so? You granted him in them for some time, number one. Number two, what is the difference between a regular employee and a contractual employee so far as the benefits arising out of the same service being given? He's giving the same service as a regular employee. The only difference is that the regular employee was regularly appointed. You took him on a contract for a particular project, maybe for a particular time or till the time you extend the contract. Where is the bar to give him any?
If lordship turns to page number 24, my lord.
24.
24.
What does
This
it
matter, the minors.
that I shall accept any pay which is given to me? Something like that.
No.
Minutes.
Page 24 is a part of the
Yes.
minutes dated 15 July 2018.
Which part do you want us to see?
Page 24, my lord, 19G. This was considered, but
Where was it considered?
my lord,
Page 34.
sorry, 34, my lord, 30, not 24, 34, 19G.
No, it was considered. What we are required to see is whether the consideration is correct or not. Her case is not that it is not being considered.
Only because that he is not a regular contractual employee, it was denied.
All the other employees are regular employees, or there are other
They are
contractual employees.
contractual employees, some are their contractual, but most of them are regular. my lord.
Those contractual employees, what kind of a pay are they being given?
Their contract have been signed, my lord. That instruction, I don't have it. What is
You
the-
have to have all those instructions because, sir, going round and round is not helping anybody. It's 2022.
2022. I have
Person
received that
joining
instruction that
he's asking for 2017.
17. ROP
He's
17.
asking for 2017.
And he has
He was
super-
paid according to 2010.
and he
Is it not?
superannuated on 29 to
Just a
20.
minute, sir. 2010, he was being paid according to 2010.
10 ROP.
Now that 2010 becomes 17.
Yes.
It is not an addition or an amendment. What is it? It is a fresh rule substituting the other one.
Lordship.
Whatever
Absolutely.
you're drawing there, sorry, sir, you will draw this. Is it not?
Yes.
Can you deny him that? You should have denied him 2010. You
Yes.
should have fixed the pay for him.
2010,
This is the scale. This is what you will earn. Whatever others get, we don't mind. You want to enter into a contract, please enter.
Allow me some time, I will file my affidavit, Lord.
When?
3 weeks time, my lord. Lordship, date, fix a date, my lord.
We'll fix a date, we'll take it up for disposal on the
Not
next date,
not-
with or without the affidavit.
Well, in the meantime, I will put up. the-
With or without the
Yeah,
affidavit, it's up to you. 3 weeks should be 1, 2, 3. 6th of March,
Let it be 9th of March, my lord.
9th of March. Mr. Esbro, Learned Counsel appearing for the petitioner, for the respondent has submitted that the instructions have been received and he would be filing the affidavit in opposition within a period of 2 weeks from today. Accordingly, list this matter again on 9th of March, 2026, allowing the petitioner to respond to such affidavit in opposition, full stop. Now, affidavit in opposition proposed to be filed, full stop. The affidavit in opposition shall invariably be filed on or before the 2nd of March 2026, full stop, on the failure of the respondents on filing the affidavit on or before 2nd of March shall entail a cost of rupees 5,000
Well, Lordship will take up as a, not there, Lordship will proceed, my lord. Not
as a cost of rupees 5,000 in case the respondents file the affidavit on or before 6th of March. From 2nd to 6th, you have to pay 5,000. Do it before 2nd, no cost.
my lord. That can be omitted, my lord. If the affidavit is not filed, Lordship will proceed as per the what available
No.
on record, my lord.
You can't keep the court waiting. We will not take your
I will
burden,
file it
allowing you to,
before- I will file it before 12.
uncontroverted assertions, doctrine of non-traverse.
Lord,
We can anyways allow today itself.
Lordship. Lord.
Let them respond.
On 9th, my lord.
On 9th,
Before that, I will file my affidavit. It will be on record.
on 2nd, you file your affidavit
Before the 2nd, my lord, filing.
so that she can respond to it.
Lordship.
Yes.
Deeply.
Obliged, Lordship.
Maybe let's not.
Yes, sir.
Here the dispute was, my lord, there's still dispute raised whether the transfer of the petitioner was legal or illegal. That was the reference of page 12, my lord, in HLP.
Page 12.
Yes. And my lord, one thing I am just to confirm whether the person is retired because she was 57 in 2022. If the age limit is 60, then he might be. So let me get instruction, my lord, let me come any day. It was retired, huh?
Page 12, it was referred. Where was she transferred from?
Transfer from Lalgarh Singha to Jatinga.
Narsinga
Eastern.
T to Jatinga Valley TE. Learned, heard Mr. Api Sharma, learned senior counsel appearing for the writ petitioner assisted by none appears for the respondents on call. Learned senior counsel has submitted that going by the date given in the affidavit, the petitioner might have superannuated from service and he requires a short accommodation to find, to have his instructions in the matter. Stop. List the matter again on
13th, my lord.
13th.
Yes.
13th of February 2026 for the instructions to be received by the learned senior
Pleasure.
counsel. By the learned counsel for the petitioner. Senior counsel instruction.
It's better that I pass out for the time being, my lord.
Please, your lordship. So in this matter, my lord, till that, my lord, nobody has filed the response, my
No,
lord.
no, it was referred to the mediation.
Yes, one.
Something happens, no.
No. That order is there, my lord. Because actually.
When you say it is not. Yes, what is the matter?
Matter is that, my lord.
Are you seeking time to file affidavit in opposition?
No, my-
No. Okay.
because I've gone through it, my lord. He has a good case, my lord, so I'll
Alright,
not
let
oppose
us
it, my lord.
But actually what happened, my lord, after my retirement, my lord, they have made the recovery from my pensionary benefit, my lord. Actually, what happened, my lord, my actual date of retirement was 2012, my lord. They have given the retirement in the year of 2016. I have.
Why did you keep working? Did you write any letter saying that, sir, please retire me? No.
This is not. I
Then
have
you
not
are,
been-
then you have a hand in continuing to work, then they can recover. You did not inform them that I have become 60.
No, well, actually.
You hid.
I
Hiding
have
of
not been
material
noticed, my
fact,
lord.
suppression of
Actually,
material fact.
my lord, later on, my lord, as per my request, my lord, I have been given the retirement, my lord.
Why did you not request it earlier?
Earlier, my lord, this is not in my knowledge, my lord. Because at that
Yet,
time,
what
my
is
lord,
your age?
yes, lordship, actually what happened, my
You
lord,
did not know your age.
I know the age, my lord. I
Okay.
know the age, my lord.
Give us the dates. Heard Mr. T. Borua, learned counsel appearing for the petitioner.
Yes.
Also heard Mr. So-and-so, learned counsel appearing for the
PNRD department.
PNRD department. This writ petition has been filed being aggrieved by the action of the respondent authorities in No, where is that letter? 12 to 18 in. Just a minute, huh? Deciding to hold back an amount of deciding to hold back his hold back the salary and other allowances with arrears drawn during the period from July 2012 to March 2016 from his retirement benefits on the ground that the petitioner had overstayed his period of service for the aforesaid time. Full stop. Next para. Learned Counsel for the petitioner has drawn our attention to the fact that the petitioner was born in the year 1952, joined in his service in the year 1983, and as such, he was required to have retired on 31/7/2012. However, due to a lapse on the part of the office of the respondent authorities in issuing the appropriate superannuation order, the petitioner had to continue to serve the department up to 31/3/2016. The Learned Counsel for the petitioner has submitted that the aforesaid superannuation was effected on him only on his insistence before the respondent department. It is noticed that the respondent department has not filed an affidavit in opposition in the matter till date, although notices were issued on when was the notice issued? Issued on 21/7/2022. Full stop. The orders which have been annexed to the writ petition do not reflect that there was any finding to the effect that the petitioner was involved in any manner while overstaying his period of service. Full stop. However, it is also noticed that cut out that however part. Cut it out. Full stop. Full stop. In the aforesaid situation following the law laid down in the case of Rafiq Masih. The citation to Bhaibi. This court is of the opinion that the respondents would not be entitled to recover the arrear salary or allowances or salaries for the period that he had stayed in service from and beyond 31/6/2012 and up to 31/3/2016. In the earlier order passed by this court, the respondents were already restrained during pendency of the writ petition from recovering the amount of proposed rupees to 10,000 from the pension of the petitioner. The earlier interim order is made absolute. The respondent shall not make any recovery from the pension of the petitioner on the ground that he had overstayed in his service from 30/6/2012 to 31/3/2016. Full stop. Further, if any amount has been recovered from the pensionary benefits of the petitioner on the ground of his having overstayed in his service for the aforesaid period, the same be reimbursed to the petitioner within a period of 3 months from the date of receipt of a certified copy of this order. Full stop. It is made clear that since the petitioner had overstayed his service on and from 30/6/2012, the respondents would be at liberty to recalculate the pensionary benefits of the petitioner, taking his notional date of superannuation to be 30/6/2012. The pension may accordingly be adjusted. The respondents would also be at liberty to issue a fresh pension payment order in this regard. Petitioner shall cooperate with the respondents in the aforesaid aspect by depositing his pension payment order on demand by the respondent authorities. Writ petition disposed of, parties to bear their own costs.
Oblige, your lordship.
Highly obliged.
Present Lordship.
Yes, sir.
Lordship, this matter, the issue is Lordship, we were aggrieved by non-consideration of our case for promotion.
Hmm.
Now Lordship, the authorities have brought a letter on by their affidavit stating that we had submitted a letter that we are not inclined to take promotion. And therefore on that ground,
Did you?
Lordship, we had made an FIR to that effect, we had never submitted.
Where
that
is that letter?
Lordship, that letter your Lordship will find in their affidavit in opposition.
Page 62.
Page
62.
62. Yes, sir.
63 is the original, Lordship. 62 is the type copy.
Yes, sir.
This is from our records, madam. This was received also accordingly. And it was filed with the petitioner that she doesn't want any kind of promotion.
She has lodged an FIR to the.
FIR, we have to
Once she
check
gets
when.
this copy, she has lodged an FIR. Let us be a bit reasonable on this. You received a letter, so you did not consider her promotion. You were not at fault. She now says, it is not by me. I have registered a police case. If it comes out that it was hers, she goes in, she loses her job, forget the promotion. Can it be disposed of by directing you to take into account her denial of writing that letter? Also, the fact that she has lodged an FIR saying that the letter was never issued by her. Consider her through a DPC for the promotions. And if she is found fit in the earlier DPCs, give her the promotion notionally without any financial implications on your shoulders.
That can be agreed.
Or at two.
Notional
You want-
malady.
You want to have your instructions. Are you satisfied with that? Have your instructions.
Lordship can.
If we pass that order, then it will be on notional benefits. If you want to fight it out, it is 6 months later or
No.
a year later by the time
Your
which we
Lordship,
decide.
even in the pleadings, we have stated that assuming if this letter was even submitted, my promotion will be cancelled for that 1 year, one select year. Subsequently, I am required to be considered for promotion. Therefore, if that.
No, if the letter,
Lordship. If that is assumed.
this letter does not say 1 year, 2 year, 3 year, whatever, it is not written by you. So let us
No,
not
Lordship,
go by the
latest-
assumption.
The latest office memorandum issued by the department.
If someone forgoes, she'll be considered on the next year.
For 1 year,
That office memorandum is of when?
Lordship, that is of 2024, subsequently.
So there's 25.
2024.
So that is of 24 and you missed your promotion in 2015. They'll consider you from 15 onwards in every DPC, wherever you fit in, you get it. But this will be a consenting order. Both the parties
I'll
have
have
to
to take
consent.
instructions.
Both the parties will take your consent. If it is that way, you have a disposal. At least the matter will proceed further. Have your at two.
At two.
At two, if it can be done that way on a consensus, we'll go by that order. If we need to argue at the matter, we'll argue at passes orders. No difficulty on each of them. You have to write down the facts in any case.
Right.
May I please, your lordship.
Yes.
Health.
They are not keeping good health
After some time.
after some time.
Lordship, this matter has become infectious because he was a contractual employee
Ah.
and already he got an alternative job, and that Assam Higher Secondary Education Council is no more there.
Ah.
So this matter has become infectious.
Learned Counsel, Mr. S.N. Tamuli, appearing for the petitioner, has submitted that the matter does not require further adjudication. Since further education as it has become infectious, full stop, accordingly the petition is closed as infectious.
Much obliged.
WP disposed of.
So the petitioner herein is seeking promotion as a Anganwadi worker. She has completed 10 years as Anganwadi helper, Lordship. And Lordship, she qualifies the eligibility condition, Lordship, for promotion to the post of Anganwadi worker. And there is an inquiry, Lordship, the selection process has been held, and no one has been appointed till date, Lordship.
As Anganwadi worker.
Worker.
Yes, madam, any instructions on your part?
Lordship, survey is going on all throughout Assam, and also, Lordship, we have sent this affidavit for swearing, signing
When did you send it?
on 3/6/24, long back, Lordship.
So, can we invite the officer who requires to sign
I'll
it
take
to
up
come
this
to
matter,
the
Lordship.
post commissioner? He requires a special invitation. We can send it.
Lordship may give me 1 week's time, I'll file the affidavit.
Lordship, may I pray, Lordship, when notice was issued in this case, Lordship, only the notice was given to respondent number 1 to 3. 4 to, Lordship, there are other 4 to 7 also.
Who is 4 to 7?
4 to 7 is the selection committee, Lordship, and the private response.
Why the private respondent?
Because I have met, because he is only class 9 pass. And
Has she
so-
been promoted as of now? No.
Not now.
She is not being promoted. Any interim orders in your favor in the earlier, on the earlier dates?
No.
Then as of now,
As of now-
selection committee, selection, you are not agreed by the selection committee. They have made the process. You may have been selected, you may not have been. We do not know. Your case is consideration for promotion.
Right.
Admitted case is considered for promotion. Writ petition closed. Is it not? Not at this stage. Miss U Sharma, Learned Counsel appearing for the petitioner, for the respondent has submitted that the affidavit was sent for vetting and necessities to be done on part of the department as back as on 2024. However, such affidavit has not been filed till date. Full stop. Ms. Sharma is given, on the request of Ms. Sharma, the department is given another week's
Week
time.
time,
The respondents are given another week's time to file, to ensure filing of the affidavit in opposition in the matter, failing which the matter would be taken up for disposal on the next date fixed with or without the affidavit.
Lordship.
Full stop. It is further made clear that if no affidavit in opposition is filed on the next date fixed, the court would be constrained to observe that the respondents have not cooperated with the adjudication of the matter and the same may incur costs on the respondents. List again on, pick a date, madam.
Lordship, any date,
Choose your date.
after 10th, Lordship.
After 10th. Give after 10th. When, basically, 17th কৰক বা 17th or 18th? মানে মই এখন চাই পেলাই কৈ আছো 17th or 18th? 17th দিয়াৰ মতে এইটো 8টা আছে 17 ফেব্ৰুৱাৰীত হ'ব এইবিলাক ছুটি মাথা মিলাই যাব
17th.
17th of February.
Lordship.
Lordship, compassionate appointment. And that 2013, Lordship.
The appearance on behalf of the petitioner has been consistent. We can afford her a few more hours after some time.
Lordship.
Affidavit filed, madam?
Yes, Lordship, affidavit has been filed and I have also filed my reply, Lordship.
Reply is not with us, Lordship.
When did you file the affidavit?
Affidavit filed on September 25, Lordship.
The affidavit in opposition stated to have been filed and the affidavit in reply stated to have been filed are not found on record.
Lordship.
Learned counsels appearing for the contesting parties are requested to verify from the
Lordship.
registry regarding any objections in the same, have the same clarified, and ensure that the pleadings stated to have been filed are on record before this court on the next date of hearing. List again on 18th? 18th of February?
Lordship,
13.
deeply obliged.
Mediation?
Kindly pass over the matter for the time being.
What happened in the mediation?
Did not succeed in Miller mediation because it did not succeeded in mediation.
They could not.
It could not.
You want some date for adjudication, or we can do it today?
Let my senior come. He's engaged in court number 3, my lord. It can be.
It can be taken up
Yes, can be
today.
taken.
Prepared?
Yes, prepared as in lordship. We have only one instruction that there was a committee which was constituted.
To your peril. If you are short of instructions, it is at your risk and
No.
peril.
No, we have been told the petitioner didn't cooperate in that particular committee hearing.
It is. He's here. Can we take it up, sir?
No.
Okay.
But here, I retired from service, my lord, but my pension is not given. This is.
They say the committee, there was a committee,
My lord.
you did not appear before the committee. Why don't you cooperate with the proceedings?
I have not got the notice, my lord.
Oh, you have not got the notice.
Yes.
Tell us a date when you can when you can go and appear.
My lord, I will. Lord. The committee. No, that's all right. Notice may be served on me, my lord.
Acha,
I
you
will pay.
remained absent
Yes, Lordship.
since 1996 without prior permission. Up to when?
Lord, that is their feeling, my lord. But thing is this, my lord, if I am absent, my lord, they would have taken some action against me. No action has been
They
taken.
could
So
not
my
raise you,
acting service.
they could not raise you out. The person who knew that you are unofficially absent,
My lord.
he was transferred out. Next person comes in, does not know of your existence. He goes out. Third person does not know. Fourth person does not know. One fine morning, you say, I have retired.
Next one number 2 is commission.
Well, if the committee is formed, my lord, definitely I will appear, my lord.
Huh?
Let notice come to me.
Have you filed a list of date
My lord,
with the writ petition?
yes.
To Director Panchayat.
Your lordship,
Hey, Harry,
list of date is there
just a minute, sir.
in the cause list.
এই এখন লিস্ট অফ ডেটাৰ সিনপসিস দিবলগীয়া নোটিফিকেশন আছিলে এটা পার্টিকুলার ফরম্যাট দিছিলে হাউ টু গিভ আ লিস্ট অফ ডেট দিয়ার লিস্ট অফ ডেট এন্ড ইন্ডেক্স ইজ এ কপি পেস্ট হাউ ডাজ ইট ম্যাটার একো বুঝিয়ে নাপাওঁ এই নোটিফিকেশন খন বিচাৰকচোন লিস্ট অফ ডেটাৰ সিনপসিস দেখিবলৈ কেনেকুৱা হ'ব লাগে হা
ফোন কৰিছা এইটো একেই বস্তু আমাৰ
আচ্ছা you were absent you have you made any statement anywhere that you did not attend services
একটা কমিটি ফর্ম করেছিল কমিটি করে ডাকা হয়েছিল বাট হি ডিডন্ট
He didn't engage.
Lord, we have elaborated that the entire period, my lord, of
when
my
did you
service.
when did you remain absent 19 you joined your services on when did you retire
My lord, retirement, my lord.
when was the retirement date
My lord, retired from service in the year 2016.
no kindly have a look at the list of dates which has been given Mr. Sheikh kindly have a look at the list of dates
My lord,
April.
what should the list of dates say
joining report, my lord, joining report.
yes tell us the date of retirement does it show that
My lord, it is not.
no it is a repetition of the index sir you have to go through the pleadings before
My
it
lord,
comes before the
that-
court
That I have stated in the petition.
Yes.
then why do we need a list of dates
2002.
you expect us to sit down and read every sentence
Your lordship,
After
I have
20 years. After 20
detailed,
years, he has
just a
detailed
minute
the
just a minute
service career, my lord.
2016 retired Retired, joined 1983. How many years of service required for pension?
25,
20 years.
20 years.
20 years,
Years. Qualifying
1983.
service. Qualifying service have to be 20 years. Lord.
20 years, okay. From 96 to 2005, how many years?
Oh, 9 years.
2005, no. 2005 is 9 years.
Yes.
1983, 1993, 2003, 2000. He completes 20 years. Add 9 years to it, 2012. He retired in 16. He has, even if you take that period to be diasnon,
Lordship.
it is still 20 years of service.
Lordship, as per our instruction, he is unpaid since April 2002, Lordship. This
Huh?
2005, what he is claiming, Lordship. This is, we have no record as such,
No,
Lordship.
1996 he vanished. When did he come back?
1996 he joined.
1996 he vanished.
No. 1996, unauthorized absence.
Yes,
No, no,
Madam
appointment.
Bhattacharjee will do one thing. We'll take this up at 2 o'clock.
Lordship.
Just find out the date of the appointment,
Okay, Lordship.
date when he went missing, date when he reported back, and the date when he was superannuated. If minus the unauthorized absence, he has completed 12 years of service or 20 years of service. Two things will come in. One, during his service tenure, you did not regularize, raise no objection, no inquiry held, no punishment.
Yes.
So that you will not do now. Because he retired in 16, 4 years gone, no disciplinary proceeding now. Since he did not work, let it go as diasnon, 9 years. It will not be taken into account for any other purpose except continuity of service. 20 years plus those 9 years, 29 years of service comes in. 29 years of service, whatever his pension comes to. Calculating his DCRG and everything, minus these 9 years. Since he did not serve. Calculate it out, pay it to him, close the writ petition.
You get the instruction.
You cannot punish him now, can you?
No.
Then why keep it pending? Whatever he gets, give him.
Can I pray that this matter will come next week? Then I will get the proper
When?
instructions. Next week?
Next week, give us a date. 9th.
Shoot, 9th.
9th?
Yes, Lordship.
Have we calculated? See, that is what we just saw. 83, 2016, minus 9 years. Still 20 years. Is it not? Can you deny pension? You can calculate the DCRG as if he was not in service. That is the best you can do. He'll come back asking for the DCRG. At least he gets food at home, which you cannot deny as of today. Place this matter again on the 9th of February 2026, allowing Mr.
A.K. Ghosh on
appearing on behalf of
Mr. S. Datta
for the Department of
PNRD.
For the PNRD department to have his instructions
Yes.
on the queries raised by this court. Yes.
Deeply obliged.
Obliged, Lordship.
বাকিবিলাক কাউন্সিলৰ নাম লিখি ল'ব আপুনি তাত এখন নোটিছ মাৰি থব যাৰ যাৰ হাজিৰাটো ৰেকৰ্ড হ'ব লাগে দে উইল গিভ ইট ইন ৰাইটিং ডিপাৰ্টমেণ্টৰ সেই তাত বহি থাকে বিচাৰি বিচাৰি নাম নিলিখে য়েছ ছাৰ
Here we had challenged the order of penalty issued against us, which your lordship will find at page.
He had filed an appeal. I tried to trace it out. The office of the governor has not received till yet. And now the office is working. My lord will pass a judicial order.
Did your office receive the appeal?
Yes. Additional Chief Secretary office has received it. But after it is paused there.
No, the person who kept that appeal hanging lost it. He will be held responsible now.
Right now, that post is also not there. Additional Chief Secretary, right, Omar? No,
we are not talking of the additional chief secretary did not receive it.
His office.
Someone down below received it. Someone down below did not put it up.
But the stamp of the stamp is my lord of the.
In any case, just tell us what is the matter about.
Page 267, that appeal has been disposed of.
Appeal has been disposed of. How do you trace it out?
11/7/2020. The additional affidavit, Lordship.
Page
267, Lordship. Of the
nine.
additional affidavit.
And
We
we
do not
don't
have
have
the
the
additional
copy of
affidavit
the.
on record.
Lordship.
We do not have the additional affidavit.
I
on
don't have,
record.
my lord. Even I don't have.
Even they don't have a copy.
Lordship.
We'll take it up on the
He modified.
18th. On the 18th. By that time, complete your, give him a copy today.
Lordship, yes.
Ensure what you have filed in the registry is brought before this court. Mr. A. Chakraborty, Learned Counsel, appearing for the petitioner, has submitted that the appeal submitted by the petitioner had been disposed of on
11/7/2025.
11/7/2025, full stop. He submits that he has filed an additional affidavit bringing on record the dismissal order. Full stop. However, the Learned Counsel for the respondent has submitted that they cannot trace out a copy of the said additional affidavit even if served on their office. Full stop. Learned Counsel for the petitioner has agreed to supply another copy to Mr. D. Gogoi for adjudication of the matter. The additional affidavit is not available in the records of the court also. Learned Counsel for the petitioner shall ensure that the additional affidavit so filed is brought on record before the next date fixed, list again on the 18th of February 2026 for disposal. Yes, madam.
Lordship, this is a petition for regularization. I'm working in a grade 4 post as a LDA typist. Affidavit has not been filed. It's been 2 years, and the last order is that it must be addressed on the basis of affidavit. Either they say they want to go on, I'm ready to go on.
Your Lordship, the matter has been listed after 2023 only. And the thing is, we have received the instructions that Your Lordship may kindly go through the instructions. The claim of the petitioner for regularization or for that matter, for appointment or any sort of that matter. Your Lordship, the post of LDA cum typist cum peon and office peon have already been filled up through state level selection committee. And right now, as such,
To your peril,
petitioner has.
at your risk, if she has a right, if the petitioner has a right, the petitioner has a right to be considered. 10 years of service.
Also,
10 years of service, continuous service, consideration.
Your Lordship, that is what we have
It is not
received
the-
under set of instructions.
Now we will impose a very heavy cost on the department because they have been issuing instructions and not following up the matter.
No,
For filing of the appropriate pleadings by which the petition can be
the
disposed.
matter actually
Yes,
was not listed.
could be. Is it not
And
their responsibility to follow
that's
it
why
up?
maybe we also might have actually, our office might have also missed out with regards to filing.
How
an
much
affidavit.
time you would require to file your affidavit?
We'll file an affidavit within 2 weeks, Your Lordship.
2 weeks?
2 weeks, Your Lordship.
Ms. G. Goswami, Learned Counsel, appearing for the writ petitioner, has submitted that although notices were issued way back in the year 16/6/2023, the department and the respondent authorities are yet to respond to the assertions made in the writ petition. Full stop. Mr. D. Bora, Learned Counsel, appearing for the child development, for the department has submitted that instructions have been received and an affidavit would be filed within a period of 2 weeks from today. This court is not happy with the manner in which the cases are being conducted. This particular case is being conducted by the respondent authorities. Full stop. Reluctantly, accommodation of 2 weeks is given to the respondent authorities to have their response to the writ petition filed be brought on record. Full stop. Accordingly, list this matter again on the 18th of February 2026. 18th would do, sir?
Your Lordship, after 18th, Your Lordship, any day after, on 28th, Your Lordship.
20. On 22/2026, by which time the respondents would be at liberty to 22/2026. Full stop. The respondents may file their affidavit on or before 19th of February 2026 with an advance copy to the Learned Counsel for the petitioner. Full stop. It is made clear that in case the affidavit is not filed on or before 19th of February 2026, this court would be inclined to impose exemplary costs for delaying adjudication of litigation. We'll have it on 20th.
Obliged, Lordship.
Lordship, may kindly pass over the matter for time being. My senior is on legs in court number 1, Lordship.
You are here. What is the matter about?
Lordship, appointment of the petitioner as peon in grade 4 post in elementary education department, Lord.
In the last occasion, Lordship, appearance of supposed to file affidavit, my lord. I found
Who is the respondent number 4?
number 4, my lord.
Who is the respondent number 4? Oh, respondent number 4 has filed an affidavit.
Secretary to the Government of Department of Student.
What do you say? Do you deny it?
My lord. My lord, only page 52, my lord.
No, kindly have page 52. Accordingly, the office of the
My
answering
lord.
deponent directed Director of Elementary Education to furnish vacancy position in the office at 2. Find out whether the vacancy position is there or not. In any case, since you have admitted that the petitioner was entitled to be considered for vacancies. Since there was vacancies when his case was being considered, trace out a vacancy. Ask them to trace out a vacancy by 2 today. Yes, madam, you also read your file. Read your file properly. You will have to assist us in getting the dates and everything. We are not allowing any other senior to appear in the matter. You are appearing in the matter.
Lordship, my senior will be.
You will appear in the matter. You will give us the dates, or it is not disposed today. Go to the file, find out the dates. When was the application made? When is the judgment given? When is the when was it sent to the department? What does the department say? You can find out the dates. Yes, do it till 2. At 2. This is item 9. Yes, sir.
May I please, your lordship? Lordship, may I first kindly come to order dated 25/6/2025.
What does it say?
There was a direction, lordship, to them. Paragraph number 3. 25/6.
Experience form, experience certificate. From where do you get it? There is an order. Have you gone through it?
Yes, Lordship.
Tell us.
Lordship, actually, Lordship, the case of the petitioner was that he had the experience, and our stand is that he has failed to upload the experience certificate.
Show us the provision in the website to upload experiences. That is what the court is asking you.
Yes, Lordship. Otherwise, Lordship, if he falls under the Lordship, that order, if he falls under the category, Lordship, to be selected, to be considered, Lordship, this can be disposed of, Lordship, because our stand is that she has got 69 marks. If 10 marks
Meritorious
is
enough.
Huh?
She's meritorious enough.
Yes, Lordship, if 10 marks is added, Lordship,
Of the
and if he falls for the experience, Lordship, and if she falls under the merit list, Lordship.
So can we say in the order that instead of going into the controversy as to whether she was required to put up the experience certificate or not, the respondents would not be averse if the petitioner submits an experience certificate now, they would have the opportunity to verify the same, found correct.
Yes.
Take further steps for consideration of her case for appointment on the basis of her merit and appoint her accordingly with a small line with all consequential benefits.
No, Lordship. That
If there is a delay, she would at least have a notional seniority, otherwise she's coming back in litigation. She will not have the pay. Let us be very clear. No pay. But when her immediate person below her on merit was appointed, would she not be deserving?
No, Lordship, but all in all, Lordship, our stand is that the other candidates have uploaded their experience certificate.
Where is that button? Show us the button. Show us a screenshot.
Lordship.
One screenshot, we are happy.
Of any of the candidates.
One screenshot, Lordship, my case is gone.
You dismiss her. Why give her that option? Dismiss her. She asks to be dismissed.
Lordship, then that screenshot, Lordship, I'll try to get, Lordship. Because, Lordship, otherwise, Lordship, the link was there.
1140.
Lordship, can
At
it be,
11:40?
can it be on Monday, Lordship?
No, no.
That's because otherwise, Lordship, there was.
In the advertisement also, Lordship, there was no requirement as such. They have stated what are the documents to be submitted.
No, Lordship, otherwise there is in the advertisement at clause 7, Lordship,
Nine,
at
nine.
page 38. It is there, Lordship.
No,
What
no,
does
it's
it
not,
say?
not there.
Page 38, 7, Lordship. Weightage for service under NHM. Many contractual MP are working under NHM as nurses, paramedics, etc. They may be given weightage of 2 marks per year of service completed under NHM, subject to a maximum of 20 marks, so that they can be given suitable and.
Just a minute.
Clause number 4, Lordship, list of documents are there.
Clause number?
4, 38 page number. The following documents in original will have to be produced. Number 1,
Where is that experience certificate?
nowhere.
No. This is to be produced for verification.
That is produced, Lordship, not uploaded, Lordship.
Yes, Lordship, then I'm coming to
No,
there.
for production, you don't even need to produce it.
Yes, Lordship. Lordship may kindly come to page number 61.
What is 60? Yeah.
Page number 61.
Just a minute. Page number?
61, my lord.
61.
Documents uploaded status. This is the form.
Permanent resident,
Permanent
category,
resident,
SSLC,
category
diploma,
SSLC.
Assam registration number. Your experience comes from this registration number.
Yes, Lordship, and I'm working under them only, NHM.
No. What I'm asking you is this. The experience certificate that you show,
Yes.
the experience is counted from the date of your registration or your date of employment under some.
Date of appointment, Lordship, date of employment.
Employment.
Under NHM. Yes, Lordship.
That is 5 years, 6 months, 4 days.
5 years, 6 months, 4 days.
Total years.
Now, there must be one column saying, are you employed?
Yes, Lordship.
Where does it say so?
That is at.
No.
the
In their form.
Yes, Lordship, page number 61 itself. Document uploaded, then two lines above. Total year of experience,
I'm
5
not
years, 6 months, 4 days. Last experience designation held. Staff nurse, NHM.
Okay, we are disposing this off. Huh? The earlier order dated 25/6/2025 passed in this petition records as follows. Take down paragraph 1, 2, 3, 4. Okay. 1, 2, 3, 4 paragraph. Stop. On 19/11/2025, a prayer was made for liberty to file an additional affidavit, which was filed on 26/11/2025. Mr. A. Ahmed Learned Counsel, M. Ahmed Learned Counsel, appearing for the petitioner, has submitted that the petitioner is not averse to producing her experience certificate before the respondent authorities in case they want to verify the certificate and allot her the marks as required under the experience column. Full stop. Mr. Upamanyu, in his usual fairness, has submitted that the respondent authorities are also at present not averse to accepting the experience certificate of the petitioner for consideration of her case for selection and appointment, however, with a liberty to have the same verified for its authenticity. Full stop. This court has noticed that in the advertisement itself at column at serial number 4, there was no indication of producing the experience certificate, nor was there any indication in the filled up format supplied with the writ petition regarding the experience certificate document required to be uploaded. In view of the consensus arrived at regarding the submission of the certificate at this stage, this court disposes of this writ petition, directing the petitioner to appear before the respondent number 2, namely the Director of Health Services, Assam, along with the original of the experience certificate claimed to be in possession of the petitioner, along with requisite numbers of self-attested copies on, yes, give us a date, sir. Mr. Upamanyu, give us a date.
On, it is
Within 7 days?
Lordship, on Lordship
No,
14.
we are not giving us 7 days time. You'll go there, he'll be in some meeting, you'll come back, you'll say he did not attend me.
On 14th, Lordship.
On 14th of February 2026, full stop.
Lordship, 14 is the second Saturday, Lordship. Can it be on 13th?
13th of February 2026, full stop. The respondent number 2 shall arrange for receiving the copy of the experience certificate to be produced by the petitioner along with the requisite numbers of attested copies. And the respondent number 2 shall be at liberty to verify the authenticity of the said certificate within a period of 2 weeks thereafter. Full stop. In case the experience certificate of the petitioner is found to be authentic, the respondent number 2 shall ensure that the marks for experience based on the certificate is added to the merit of the petitioner, and thereafter the same is placed before the appropriate authority for considering the case of the petitioner for selection and appointment on the basis of the total merit acquired by the petitioner. Full stop. In case the petitioner is found fit to be appointed, the said appointment process shall be concluded within a period of 6 weeks from the date of the certificate being found to be authentic. Stop. Anything else to be said? Nothing.
Candidates should be considered, Lordship, within the category of scheduled caste, Lordship.
The petitioner claims to be a candidate of the scheduled caste who is entitled to be given the petition benefit of a scheduled caste category candidate. Full stop. Respondents would verify the same and act accordingly.
And Lordship, if appointed, Lordship, then seniority may be fixed nationally, Lordship.
No, Lord.
Otherwise, Lordship, I was entitled to if I am appointed.
Have you seen a toothpaste tube at the end of it? Press a little more, something more comes up. If they don't give it to you,
You can always come.
Lordship.
These doors are physically closed, but otherwise they are always open. Yes.
Obliged, Lordship. Highly obliged.
Can I take up this matter? Name of the petitioner. Can I take up the matter? Yes.
My lord.
What is the matter about?
My lord, the matter pertains to, in fact, there have been 2 litigations prior to this, my lord. The basic facts, my lord, is that the petitioner's father passed away in the year 2006. At that point in time, there was an OM, my lord, regulating compassionate appointment in the APDCA. At that point in time, my lord, the petitioner's mother had preferred representation before the authorities for consideration of her claim to be appointed compassionately, my lord.
They did not do so.
They did not do so. My lord will kindly come to page 50, my lord. Page 50.
15.
50, my lord. This is the petitioner, my lord, initially, who had moved before this honorable court in the year 2020. There was an order, my lord.
2006 in 2020.
My lord, yes, there was an affirmative order, my lord, from this honorable court.
2022, man.
The order was dated 2022. The writ petition was 2020. The order, my lord, starts at page 52, my lord.
Thereafter, what happened?
Thereafter, my claim was rejected, which is at page 55. My claim was rejected, stating that my claim could not be entertained at the relevant point in time when the OM dated 2004, 2005 was in force. (2005) OM, my lord, your lordship will find at page 19. Page 19. The 2005 OM, my lord, was restricted to the categories which have been laid down under paragraph number 2. The existing provision of appointment on compassionate grounds shall be limited to the following cases only prospectively. A. Serving employees killed due to extremist violence while on board duty.
Understood. When did he expire? When did
He expired, my lord, in the year 2006. Now, my lord, my submission, my lord, is that the OM of 2006, 2005 is a beneficial legislation. That was subsequently improved by the OM, my lord, at page 20, which is 2014. 2014, my lord. At page 21, your lordship would see the date of effect. This scheme will take effect from the date of notification. Thereafter, my lord, page 23.
Sir,
my lord.
From when should a notification be made effective? What would be the retrospective part of it?
My
What
lord.
happens to notification? We will keep for arguments in a better footed case.
My lord.
Presently, 2006, the death.
My lord.
2020, the first approach to the court.
2020, yes, my lord.
Rejection in 2023.
2020, yes, my lord. The first rejection.
2023. Thereafter.
Thereafter,
the writ petition in 2023. Now, can we overcome the standard laid down saying that compassion would not be a ground? Number one. Number two, only on the basis of compassion, whether it be the mistake of the departmental authorities or the petitioner's lapse, compassion would not come in.
my lord. The first instance.
We will hold them guilty of not processing your or not letting you know. But that had to be done in the earlier round of
That had to
litigation.
be done in the earlier round of litigation. In fact, my lord, the first instance of an action from the government in this regard, my lord, took place.
It doesn't matter if because of the inaction, if a considerable amount of time has passed,
My lord.
compassion will not come in.
True, my lord. In fact, I am here before this honorable court, my lord, on the strength of 2 earlier orders.
Court order.
Court orders.
True.
True, my lord, yes.
There were court orders in favor of some persons.
My lord.
Supreme Court considered everything.
My lord.
Then came to a conclusion that compassion cannot be granted. That was not restricted to those circumstances.
True, my-
It was made a,
True.
it is for everyone to follow.
True, my lord.
We overcome it.
In fact, adversity, my lord, rarely improves with time. But again, since there is an order of this,
Adversity does not improve, it rather degrades with time.
my lord, but I'm not
Man goes
harping
from-
on that point. Absolutely not, my
But
lord.
then the
You know,
compassion goes. You
the
see,
compassion goes, my lord. In fact, in this regard, where compassion might be attributed in this regard is that I was a contractual worker for the APDCL, the fact which cannot.
Vedana remains, homo Vedana goes. That is the problem.
My lord, page 42. Page 42. I'll not argue beyond. Your lordship is very correct, my lord. In fact, I'm only on the retrospectivity of a legislation.
Can we do, even if we decide it here, end of the day?
My lord. Page 42.
Understood.
Yes, my lord. I have been working.
2018.
18, my lord.
Then, and you have been working.
I've been working, my
So
lord.
adversity has improved. Oh,
Adversity, my lord, this is a contractual employment.
So be it. So many people are facing it.
My lord, in fact, what had happened is the tenures are limited in this matter. My lord, he is not a regular employee. If your lordship can pass an order directing them to only consider my employability with the APDCL
As
looking
a contractual employee, at par with other contractual employee without compassion.
then I'll be grateful for that. My lord. I'll
That
be
is
grateful
not
for that.
compassion.
I'll be grateful for that. If there are other similarly situated individuals who are working as of now along with the petitioner, I may be considered with them. That I'll.
My lord, I have to take instruction on that, but my lord may pass that order with minimum pay scale, whatever. If he's still in service, we will give
No,
them.
no, we will say this will not, this order will also be construed as an observation to the respondents that the petitioner would be entitled to such service benefits which are being given to other similarly situated other contractual employees serving with the petition. That you are under an obligation to do, and
That is anyway, Upenda's anyway applicable for all the contracts.
whatever you make applicable. This will not preclude you from granting him the benefits or preclude him from raising such claims and grievances as he may be entitled to in law. Only the compassion part goes.
Yes.
The very fact that he is working as a contractual employee takes away the compassion.
My lord, I have, maybe he's been getting the, if he's working, because all the APDCL employees who are in contractual, they are been getting the minimum pay scale as followed by Jagjit Singh and followed by our honorable court Upendas. So if that observation, my lord, would not even hamper the APDCL because that is there. So
But then we are talking of an ideal situation where
Yes.
everybody is getting it.
Yes.
That is exactly the place I think they call heaven, where all are treated equally.
No,
Yes, heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. So-and-so learned counsel appearing for the prayers made in the present writ petition were for direction to the respondent authorities to consider the case of the petitioner for appointment on compassionate basis.
My lord.
In a grade 3 or grade 4 post.
My lord.
By relating such compassion to the demise of the father of the petitioner in the year 2006.
2010.
The learned counsel for the petitioner has submitted that when no action had been taken to consider the case of the petitioner for compassionate appointment.
My lord.
On the death of his father, the petitioner had approached this court in the year 2020,
my lord.
Initial first time?
2020.
In 2020. And by an order dated
29/11/2022.
Passed in WPC number
4796 of 2020.
This court had directed the respondents to take into consideration the case of the petitioner and to pass necessary orders thereon. The learned counsel for the petitioner has submitted that
representation.
State representation had been the representation filed by the petitioner was disposed of by the respondent authorities, which order is now under challenge in this writ petition. Full stop. After some Mr. So-and-so has also made his submissions with regard to the delay, long lapse of time which has passed between the death of the father of the petitioner and the present litigation, and has submitted that in view of the settled position in law as of today, the case of the petitioner does not deserve a consideration on the basis of compassion only, full stop. After some deliberation in the matter, the learned counsel for the petitioner has submitted that the petitioner is presently serving as a contractual employee under the APDCL authorities itself.
My lords.
But and he is under instructions that the petitioner is perhaps not being afforded all the benefits as are being afforded to other employees who are situated similarly, full stop. although the Learned Counsel for the APDCL has controverted the said submission, this court is of the opinion that even in the event that the petitioner's case for a regular appointment or regularization cannot be considered on the ground of compassion, since he is serving as a contractual employee, the APDCL as a role model employer is required to ensure that he is given all the benefits as are being given to other employees who are serving the organization in contractual basis. Mr. Sharma, Learned Counsel appearing for the APDCL, has submitted that the APDCL in all fairness would ensure the same, full stop, and any defect if pointed out by the petitioner in his benefits shall be appropriately addressed by the concerned authorities, full stop. In view of the above, this writ petition, the prayers made in this writ petition for appointment oblique regularization within the APDCL itself on the ground of compassion is cannot be accepted by this court, full stop. Accordingly, the writ petition is closed without granting the reliefs prayed for by the petitioner in the writ petition. However, the respondent authorities would ensure redressal of grievances of the present services of the petitioner if any grievances are raised.
My lord, and if he's still serving, because that's of 2018, the contractual.
We are not on that. He says he's there. We said it is so. If he raises a grievance, address it. We have not even asked you to.
Ungrateful man.
We have asked you to address it.
Yes, ma'am.
Address it.
Ungrateful man.
It may be to a wrong address, but address it. Yes. Yes, sir.
Please, your lordship. This is here the petitioner challenged the discharge order whereby he has been discharged from service.
Which is the discharge order, sir?
It is a page 17, your lordship.
17.
17.
Why was he discharged?
My lordship, the factual effect of the case is that I was granted leave to go home. My initial appointment was on 7/10/2004. According in the year 2022, I was granted leave to go home, whereby I met with an accident there in my hometown. So I was admitted in the hospital and my leave was extended, due permission. Thereafter, on 26/8/22, I rejoined in my duty, where my medical checkup was done. Here they downgraded my medical category, your lordship. Thereafter, on 31/12, without any intimation, without any notice, without any warning, they issued me this discharge order.
Okay.
Now, in their reply, they have said that I have requested, submitted that I should be released from service.
Where is that letter? They must have given a copy of it.
They have not given me all these things. Well, in this reply, I could find all these things.
In the reply, in the affidavit in opposition, you have given the document, madam?
Page 46, your lordship.
Annexure A.
Page
Annexure?
First, from Annexure A, page 45, affidavit in opposition.
Does it say?
First, he have.
Commandant interview.
Yes, he had requested a unit commandant for interview for proceeding on discharge. He was interviewed on 7/3/22. Page 45.
Yes, you must be maintaining a register where the signatures are taken for this
Last
interview.
24, serial number 24.
Now, serial number 24 is his name.
Yes, sir.
All the handwriting at the top of it are same.
Yes.
Is it not? So when he going for appearing for that interview, he must have signed a piece of paper. I have successfully been interviewed. Where is that?
Yeah, this is not annexed, but annexures page 46. Page 46 is his
And what is this page 46?
his application for discharge from service at own request. This is on dated 9 March 22.
It was recommended by the Corps Commander on 10 March and by the Commandant on 19 March. After that, Board of Officers were assembled to consider his case. And page 48 is the findings of the board.
So why do you not insist on the date in page 49?
48.
You see, the person does not fill in the date. There is a seal,
Annexure C.
annexure E, madam.
Annexure E.
Page 40.
Annexure E.
Yes, Annexure E.
Kindly see.
No objection certificate.
The first commanded interview at page 45
Yes.
does not contain the person's signature. Is it?
Yes.
That register that he has attended. Yes?
Yes.
Then at page 46, kindly see, he does not give the date below his signature, number 1. He appears to be a Murugan V.
It is printed in the printed form.
He has signed in a printed form.
Yes.
He does not put his date there. It is just a signature, is it not?
Yes.
The dates are put by the one and the same person, 9, 10, 19.
Right.
The dates are by the same person. Could not have been. Could it have been? Different persons are signing on different dates, but the dates are exactly the same handwriting to our eyes. Then kindly come to the Board of Officers, which was done. Now, this recommendation of the commandant and everything, this recommendation sheet, this recommendation page, findings of the board,
Yes.
it does not contain, anywhere it does not contain his signature. Then what is the reason?
Then he has submitted no objection certificate, page 49.
No. Tell us this. Recommendation of the board. Kindly see the recommendation of the board at page 48A.
48.
On examination of the application and service book of the individual, it is established beyond doubt that the request for retirement. Is it not retirement?
Retirement.
Retirement. You are
Retirement
talking
is
of a discharge. Retirement can take place only when the qualifying service has been completed. This board does not even look into the fact whether 20 years has been completed or not, and they are recommending a retirement. Then on the next page, if you come to the page 50.
49, he is no objection.
At 49, now we have given up 49. Please come to page 50.
And 50 is undertaking.
What is that undertaking? I certify that I fully understand that in the event of my
Resignation.
what did the board recommend?
That's exactly
Retirement.
Retirement.
What does now that undertaking he is signing by the command before the commandant? Resignation. Yes, madam, not happy.
Even after that,
Not a happy situation.
again, he has submitted application for discharge in 2023. Again, he was
So
interviewed.
sorry to say again that 21st date is the same as that of 9 and 10. Look at the handwriting.
Yes.
The problem is the person has a very beautiful and specific handwriting.
Yeah.
The handwriting is identifiable. It is not a routine handwriting. Do you see? It is very clear, very.
Produce the
Do
records.
what records? What will show? These are the photocopies of your records.
Yes.
But twice he has submitted willingness certificate to go on discharge.
Everything was prepared. I was just instructed to sign on it.
The moment a person is resigning, it is settled law. The employer has to give him what do you call it? They have to consult with him. What is it called? To make him understand.
Yes, interview.
That sir, look, you are going to lose this. You are going to lose your pension. Right. Now this board which set, this board.
Before that, he was interviewed.
Interviewed to do what? He was asking for discharge.
Yes, in a
How many people were interviewed on that day? 25 people.
Page 31, brief facts of the case, Roman 2, it was stated that he was interviewed and he was.
We are not believing his writ petition statements for the time being. We are not going to your affidavit for the time being. Kindly see page 45, 25% before the commandant
Yes.
or the adjutant, is it not?
Yes.
Before whosoever it is.
Yes.
Commandant interview, 25%. Could he have explained to the petitioner that if you ask for a discharge now, you will be losing out these things in your career? Please go and reflect, come back tomorrow. 24 hours reflection is what everything gets.
No, Lordship, regarding 25,
See the quickness, 7393.
except the petitioner, others are regarding leave for interview for leave. All these are-
The moment the petitioner says that I want to go home,
Yes.
the commandant has to say why.
This is not for.
If you go home, this will happen, that will happen. Someone will have to tell him.
Yes.
Is it not?
Yes.
When was it done? We all we have all gone through this part of the law at different points to see that particular consultation, that particular trying to convince the person that you are going on a wrong path.
Yes.
The resignation, you will lose.
Yes.
Your family will be a problem. Think it over. Come back tomorrow.
Statement has been given, Lordship.
Now,
that
where is that statement?
statement
Show us.
at page 31.
Page 30.
31.
Show us the document.
Documents.
Once the law is settled,
Nothing has been annexed from that.
the affidavit will be sufficing the law required. Show us the document. Kindly see. The board is to assemble on?
Yes, page 49.
The board is assembling when? 28th of March.
28th of March.
Recommending for what? Retirement.
Retirement.
So the board recommended that this person can be allowed to retire. He has 19 years of service and 2 months and something.
But next line, therefore, the board recommended that his application may please be processed for discharge from service and on request.
For the genuine benefit of future benefit of the individual.
Yes.
Now the future benefit of the individual will only come in if he gets a pension.
Yes.
On retirement, on discharge.
He comes under NPS.
Whatever be it.
Yes.
Whatever be it.
Yes.
19 years, 2 months.
Yes.
He's going out.
At that time, 17 years.
No, Lordship, 19 years, 2 months.
19 years.
2 months.
He was discharged on 19 years.
Yes. And the same
But
person.
applied in 22, it was 17 years.
No. It's more than 19 years.
But as per the recommendation of the board, last line, therefore the board recommended that
Yes. Now please read the top
application may
part.
please be processed for
See,
discharge.
page 49, we take it to be very authentic certificate. A very authentic certificate. All right.
And 49
Just
is
a minute. Page 49, we take to be very authentic. What did the petitioner sign? Certified that I have applied for discharge from service before completion of pensionable service. Before completion of pensionable service, this person is still under the impression that on 20 years I get a pension. At my own will, no coercion, threat, pressure, inducement, whatsoever has been used by me.
used to me by authority.
Kindly see by whom? By whom?
By authority in
Not because of the family pressure, not because of his health condition. He specifically, sir has not forced me. Who is going to make you write that? Then come to the certificate given by the commandant.
Yes. Who has
applied for
resignation?
Resignation. Did he apply for resignation? He asked for a discharge. Is it not? He never applied for resignation then. On compassionate ground, has been personally interviewed. It has been explained to the applicant that no pensionary benefits will be admissible to him. Where is it given? When does he say so? I understand that there is no pension. He does not say so. He never understood what happened. Yes, on a hearing day when have all the answers, we'll dispose it of.
But otherwise, he himself submitted this willingness certificate undertaking all this. But technically, on
Documents
technical
are
ground.
perfectly correct, madam.
That's it.
Documents are perfectly correct. Not in his handwriting. There is not one document on record in your affidavit in opposition.
He signed it.
where he has given it is in his handwriting. One sentence.
He signed his documents, but there's
Yes, what is his educational qualification in the discharge certificate? Show us. There is a discharge certificate.
Lordship.
What is his educational qualification?
He is, as per instruction, he is 12 pass. 12, Your Lordship, page 18.
Page
18. Highest civil education, 12. As per my instruction goes, is 12 plus.
What is his age?
because it is signed by him, though that was not of his
Page-
handwriting.
page-
He signed all this undertaking willingness.
So we'll have to take it two ways. Class 12 person can write in his own handwriting. He has not given it in his handwriting. It's a format being signed. Or he is not educated enough to write in his own handwriting. Was it explained to him in a language in which he understood everything?
Page 72 at the time of discharge, 39 years, 7 months, 12 days.
Hearing day, when?
Lordship,
On a hearing day. It will require some judgment. Next week or some others. Be holding up others today.
Oh, pardon, what had-
Uh,
So today it is not time.
next week, Your Lordship. Next week, Your Lordship. We kept it, Lordship, as
23rd. 23rd, yes, hatta dekha ase. Oh, hearing then hobo na 24th hobo te. 24th na hobo, 25th na, 26th. 26th of February 2026. After some hearing in the matter. No, the matter has been heard at some length. Listed again on the 26th of February 2026. For further hearing.
Lordship,
Have these documents, have these answers?
Yes.
Lordship, keep it.
Person actually resigning and coming back and saying that I don't want to resign. After the resignation is accepted, we will not entertain him.
Yes.
But a person who did not understand what is going on, could he have the chance to reconsider?
He has applied twice in 2022 and 2023.
So 22 will have to shun it away. Once you did not accept it on 2022, whatever happened under 2022 will have to go away.
Because
If he has applied afresh in 2023, the entire process has to be done afresh in 2023. You cannot depend on what happened in 2022
Yes.
to give him a discharge in 2023. These aspects, please point it out to us on 26th. Because if he did it in 2022, you followed a process.
In
When he
20
applied in 2023, did you follow the whole process again?
Because he met with an accident and an inquiry was pending. Therefore, this discharge order was kept
So therefore,
pending.
if it is due to the pendency of an inquiry,
Inquiry.
would you have accepted the discharge? Is it not? You could not have. It has to be brought to an end.
Again, he
Otherwise, what if we allow discharges to take place on the basis of pending inquiries? Give some big charges,
No, not-
something
not
which he cannot.
inquiry.
There'll be two things.
Yes.
One, do whatever you want in the force for the personnel. Moment the inquiry starts, pray for a discharge, go home. Or you want somebody out, level allegations against him, force him to take a discharge. Two things it will happen. So during pendency of an inquiry, person cannot be allowed to leave the job without the department inquiry being closed. In this particular case, if you take the ground that because of the inquiry he was asking for a discharge, you knew he was trying to escape a penalty. Why did you allow him? Then the officer who allowed him would be in the soup. Let us not go in that direction. We'll try to find out whether there was a genuine intention to seek a discharge, whether he was given the proper counseling. Is it not?
Counseling again, it as per the records, there is.
And then he again applies for a discharge. So whatever was done on the first application is erased out. Was it again followed in the second instance? If not, what is the relief? That is all we have to say.
Lordship, kept as part of your lordship.
Read the order. Yes.
Obliged.
Next please. And these are things which should come from you. Compassion. Experience may take away compassion. Yes. 20.
And the petitioner retired 2 years back. Pensioner is not released. Only thing is that there is the grievance of the petitioner is that the pension, regular pension not released. Secondly, there is a departmental proceeding and Sensui 7 under Rule 7 on of Assam disciplinary penalties imposed, but there is no findings why this penalty is there. Only some observation is there, and that is why aggrieved by this is challenge this.
What are you challenging? The censure?
The order after departmental proceeding. The
Where is that order?
Page 56. Inquiry committee report suggests that only suggestion is there. So no findings is there. And this
Page
is
50?
56 month.
Who is the person?
Forest Deka, he was the headmaster. Once he was suspended, then reinstated by this Honorable High Court. After that, DP is directed to conduct. And DP was not half-hearted DP, my lord.
Madam, kindly find out.
Not sure.
The name rings a bell.
Not sure.
The petitioner's name is coming here.
Not sure.
Kindly find out if at any point of time. Any earlier cases filed by?
Yes, your lord.
Yes, earlier cases is
But,
filed.
Where is that order?
My lord, earlier case are at page 46.
Page 46.
Six. After suspension, this repetition file, this order is there and it is reinstated.
And only one case.
Yes, and contempt petition is there because they are pending, kept up with pending, then they have concluded DP without evidence, without anything, only observation is there.
We'll go into all those things only once we are convinced that we have not
Only thing is that my
applied our mind earlier to this.
they
Ms. Musari, can you assist us in that manner?
Not sure.
This 6991 of 2022 writ petition at page 46
Not sure.
and the contempt case.
Contempt.
There's some contempt case.
Yes, your lord.
All these, all the orders in this case,
Lord
in these two cases,
Yes, sir.
kindly find out and also have your instructions whether
Not sure.
at any point of time we had expressed an opinion.
Not
If
sure.
not, because many a times it so happened we went through the cause list.
Yes, your lord.
Remembered because of the connection with some familiarity in the name. Na?
Yes, your lord.
Find out if it is not there, we'll take up the matter.
Then,
If
yes,
it is
sir.
there, we'll just
Yes, sir.
for some time.
21.
Make user losses. This case leads to provincialization of service of the Gate 4. But in this case, my lord, petitioner was dropped initially. He was working in the high school. Then the high school is amalgamated to one ME school, my lord. And in the ME school, one vacancy was there. Then I have filed one representation to accommodate that. And then lordships kindly see the page. Page 47, my lord. It is the parawise comment in WPC number 4756 2018, my lord. Albasuni Lasvanchi.
number
Last
40?
para, last para.
Is number 40?
47, Annexure 9. It is written like that, my lord. However, if the
Provincialized as amended census and national. occurred after amalgamation of the school of Sankota Balika Harvard. Giving the for giving the benefit of provincial letter.
Then Lordship, I approach this honorable court on basis of that. That is page 49. The order has been passed by this honorable court on 19th, my lord.
Was sent back to the department.
Yes, my lord.
And where is it?
Then speaking order has been passed, my lord. That is page 19, page 51, and except 2.
Yes, then what happened?
Then against that order, my lord, I approach this honorable court. In the meantime, I filed
Page
contempt.
57.
Because,
Page 57.
51. 51 is
Against-
the order, speaking order.
Against this speaking order, you approach this court.
Yes, my lord, that is 54 annexer. In which, my lord, I have approached the honorable court by way of filing a contempt petition. That is annexer 12, page 52.
They were
Then-
required to call.
Yes,
say that
then lordships, my lord, kindly peruse the page 54's judgment, my lord.
54.
55. If
Lordship,
that-
Lordship was here in this matter, your lordship.
Which matter?
In
Is it?
this, yes, your
Where?
lordship.
Page?
3224. Page 54, your lordship. 53. 55, your lordship.
Oh, R. Mojumdar, yeah. I'm sorry, my lord, this.
I opposed it.
Actually,
Since
what
I
happened in
opposed
this
you,
case-
since I opposed you, I cannot dispose you.
Very kind one.
List before a bench without me.
হেৰি শুনাচোন মই এখন এফিডেভিট দিছো কোৰ্টৰ অৰ্ডাৰ এটা গাঁঠি দিছো সেইটো মতে পাওঁ যদি তুমি
ঠিক আছে।
That is the inquiry we have asked her to take up in another matter also. The name was coming here again and again.
So unlucky. 22 in this case, my lord, petitioner is working as an assistant teachers in the year 1988, my lord, by the managing committee, my lord. School was provincialized. Then it was rejected because their name is shown as second DP, my lord. But then I approached this honorable court on basis of Jiman Chandra Deka, my lord. Then they stated that high power committee stated that I am drop teacher, my lord. That is page, my lord, page 77.
You had to go before the high power committee.
Yes, my lord.
Then at page 66,
77. Baksa,
page
district. Baksa.
77,
Yes, my lord. The matter of Syed,
77, yes?
yes, the matter of Syed Farooq Hussain Khan, Bhogpur ME Madrasa is placed before the HPC. The committee finds that the relevant records and documents in respect of the petitioner are at par with the criteria are applicable for elementary level defined notification 2003, which are laid before the adjustment of drop teacher. Hence, the petitioner is found
Recommended.
eligible. Yes.
Then-
But till today, nothing has been done, my lord.
Oh, yes.
But Bodoland Territorial Council, my lord, passed an order. And
Page?
that is page, my lord, page 85. Director of Secondary Education wrote a letter to the Secretary of the Education Department, Kokrajhar, proposal for regularization of service of drop teacher Syed Farooq Hussain Khan.
Seeing what? Okay. And what is this 89?
Then 86, Lordship, kindly peruse. It is also stated that in this connection, it may be mentioned here in
No,
that as
from,
per the 6 of the minutes of the high power
From the
committee.
PTC, everything is positive.
But yes, my lord.
What about
But
the- what is 89?
Secretary, Assam government,
My lord, an important order, my lord.
What does it say? That is what you want to know.
My lord, page 90, my lord. My lord,
89.
a hearing was conducted by the DE, my lord. To, as per
it is
honorable,
rejected by the claim of
Just a
the
minute.
petitioner. if his name is not shown in the DP, then a hyper committee shouldn't
Huh?
should not say that it is he is eligible, my lord. Hyper committee already been considered. Secretary said that his claim is rejected because his name is shown in the second DP. But the another one also there, she has already been regularized long back, my lord. This is my case. Bodoland Territorial Council have done everything, my lord.
Is this approval of name in the year 1991 is necessary approval?
My lord.
The order dated 18/4/2023 says the claim that there is nothing to show that the appointment of the petitioner was approved prior to 1991, prior to the provincialization.
Prior to the provincial.
Why is it necessary that the approval should be prior to 1991?
As per
Should
my
the
lord, 77
appointment be prior to 1991 or the approval?
Appointment, my lord. For
Appointment.
1977 final rule.
The appointment has to be prior to 1991.
Seventy-seven 5(3) rule, my lord.
Eh?
As per Assam Elementary Education Provincial Rule 1977 5(3), my lord.
Page.
Page 303.
303. What the? What does it say?
My lord, 5, my lord, condition for taking over elementary school, my lord, 3, the teachers in Spencer School may be retained at the time of taking over if they possesses the minimum qualification and age for recruitment, provided that such teacher have put in at least 2 years continuous service immediately preceding the taking over the school.
2 years.
2 years has gone because he is working in the year 1988.
Subsequently, my lord, second criteria is his name has been sent to detailed particular, my lord. If assuming that he is 2 years before, my lord, as per Annexa 1, my lord, but his name was not sent.
So therefore he became a drop teacher.
My lord.
Therefore he became a drop teacher. Therefore the high power committee said that those who have been provincialized, his case is at par. Now if we take his appointment to be of 88.
My lord.
And the school was provincialized in 91. Approval was in 92. But the appointment, the commissioner and secretary has not looked into the appointment part
my
of it.
lord.
Now that approval letter, where is that approval letter?
Approval.
Where is the approval? Has it been contested anywhere?
Annexa 535.
Annexa 535.
Yes, page.
Page 35.
Yes, now kindly see the following teaching staff appointed by the managing committee. Is it not?
My lord.
Farooq Hussain, 15/1/88. Approval is come in 1992.
92.
Appointment is of 88.
88.
School provincialized in 92. 2 years gone.
And lordship,
Hey.
the number one is already been regularized.
Okay, बोला गया, हाँ?
Number one is already been regularized. The same DP. She's working and I have
What is
annexed that
DP?
the said
Detail
that
particular.
details said that the Fikur.
She is appointed later than this man.
Yes.
She was appointed in 11/91.
91.
Your commissioner says that, look, sir, the school was provincialized in 1991.
Fikwa
Therefore,
Begum.
Ms. Sayeda Tafiq did not
1 o'clock.
complete 2 years.
My lord.
She could not have been provincialized. Yes?
Yes, ma'am.
Now, this man is of 88. 1991, 3 years gone. There is a this trolley car between the North Guwahati Bank and the High Court Bank. It goes from this side to that side, comes back from that side to this side. Now, if we send it back, it will again come back. We'll give you 2 minutes.
Of lights.
Come back.
নালাগে বেছি এইটো এই ইনষ্ট্ৰাকচনটো লাগে ৰ'বা এই লাইনটোত
একেবাৰে পঢ়ি আহিছে, একেবাৰে কিতাপ লৈ আহিছে।
প্ৰজেক্টত ফোন আছে চাব লাগিব না
পাম বুলি সেইবোৰ মই পঢ়ি
Thereafter, Department School Education Concern Constitute Committee verified record pertaining to matter fight so and so. Accordingly, hearing was conducted on 9/3/2023 on perusal of record.
Who was heard? Who was heard?
The petitioner, madam.
Where?
Petitioner was called for hearing in Director Office, my lord.
Read. Also read.
Accordingly,
Only.
hearing was conducted on perusal record. It is observed that the petitioner's name was provisionally approved by DU Kamrup on 10/1/1992 against the school, but the school was Provincial Indian 1991. As it is prepared honorable High Court order to so and so. Hence, it is obvious that the required approval is received after provision of the concerned school. That is the reason High Power Committee meeting rejected the claim of the sharing the name of the petitioner was not listed detailed particular submitted in the name of consolation. On the other hand, the present hearing to neither the petitioner nor the concerned stakeholder could produce any other authentic document in support of the fact of required approval in the name of the petitioner receiving 1991. In view of the above claim of the petition regulation, petitioner.
Where is that High Court order which had directed the commissioner to take a call?
WBC 7027.
Page 70?
2327.
That is any order.
Yes. What does it say?
70 page.
Just a minute.
$71 starts.
Remand back to the case of the petitioner. Ensure appropriate reason thereof stated, either accepting reason in such claim.
Kindly see. Kindly see page 71.
My lord.
The only reason for rejecting the claim of the petitioner for provincialization is that the High Power Committee found his name to be not included in the detailed particular submitted at the time of provincialization. Thereafter, if you see at paragraph 8 on the next page, that communication is set aside and a matter is remanded back to the respondent. Therefore, the finding of the High Power Committee is set aside. Yes?
My lord.
The finding of the High Power Committee that since his name does not appear in the list of DP can be the only reason for rejection is set aside.
My lord.
Is it?
Yes.
So now the Commissioner and Secretary, depending upon the earlier, the one that
Earlier.
has been set aside, that is wrong?
No.
Number one. Number two, paragraph 5. Come to paragraph 5. Mr. N. Sharma, Learned Standing Council, seeks to explain the approach by stating that the teachers who were working at the relevant point of time are included in detailed particulars submitted by the authorities, and as the petitioner was perhaps not working, his name was dropped. Right? Said may be a plausible explanation why the case of the petitioner was rejected, but such communication not being incorporated in the communication dated so-and-so, court cannot take cognizance of it. Now, in the present order where you have rejected, you have not taken this ground.
My lord.
that he was not found to be working. The only ground taken is approval is after provincialization. Is it the fault of the petitioner when it comes to approval? Mohor Ali Sheikh. Yes, 2011 Provincialization Act, Mohor Ali Sheikh. When the recognition will be issued is not his problem. If the application is prior, then the recognition is deemed. Once it is given, to relate back to the date on which he filed the application. Similarly here, the approval of the appointment is given. So the approval dates back to the appointment itself,
My lord.
meaning thereby he was appointed in
Appointed by
1988.
88, my lord.
Having completed 2 years of service, requires the regularization as has been given to others. No going back. No trolley. Now it will go only up. It will not go back. Heard Ms. K. D. Learned Counsel appearing for the petitioner also heard Mr. B. Talukdar.
Respondent 1 and 2.
For the
Education, respondent 1 and 2.
Education Department. Full stop. The primary challenge in this petition is to the order dated 18/4/2023, passed by the Secretary to the Government of Assam Department of School Education on 18/4/2023, rejecting the claim of the petitioner for regularization/provincialization of his services. The matter has a checkered history. The petitioner claims to be appointed by the order dated 15/1/1988 by the headmaster of the Bhogpur Emi Madrasa, according to the decision of the managing committee of that relevant point of time. The approval for the appointment of the petitioner came on 10/1/1992, approving the appointment dated 15/1/1988. The school came to be provincialized on the school came to be provincialized in the year 1991, and since the particulars of the present petitioner had been dropped from the detailed particulars submitted for provincialization at that point of time, the petitioner not avail the benefits of provincialization and at that point of time, full stop. Several similarly placed persons had approached this court by filing writ petitions, one of them being CR 1571 of 1998, titled Jibon Chandra Deka and others versus the state of Assam. Full stop. The aforesaid writ petitions were disposed of by directing the respondent authorities to frame a committee to look into the grievances of the petitioners and petitioners therein. Full stop. The relevant portion of the order dated. Yes. Is this order dated? First day of September 2023 is reproduced herein below for a ready reference, page 42, para 6. The petitioner in this writ petition also approached this court. Yes, madam, by the WPC number.
Approach this court, approach this court earlier, my lord.
Page 44 onwards, where is your number?
62, 3802, 2015.
Serial number?
62 page.
No, page 48 to page 49. Are
48.
you there in this? What is an extra 7?
Jiban Chandra Deka.
Upon Kumar Das, what is that?
Kumar Das, yes. That is 44. Annexure 7. Upon Kumar Das and.
Are you there in this in these repetitions anywhere? No.
No, no, no.
Okay.
I
Then you
was
cut out
in-
that the petitioner then preferred. You cut out that line. You say other writ petitions bearing WPC number 3976 of 2025 were thereafter filed. Where this court by order dated 1/3/2007
7.
directed as follows. Then you will take it from page
56 para.
30, page 56, para 9 onwards.
Yes.
Full stop. A notification was thereafter issued by the government on 16
10 July.
7/2010
110.
calling for applications. Full stop.
Then he approached, my lord.
The petitioner, on not being granted the relief, approached this court by filing WPC number 3802
3802, 2013.
2013.
Yes.
Where by order dated 23/6/2014, this court observed as follows. Page 64.
64, having regards the aforesaid submission and
To 64 and 65,
65.
A2A, huh?
Yes.
The case of the petitioner was thereafter placed before
Hyper committee.
the High Power Committee, which by the order dated 9th of February 2015 gave a report that the name of the petitioner was not listed in the detailed particulars submitted at the time of provincialization of the school, and therefore the High Power Committee did not recommend the name of the petitioner for regularization of services. Full stop. The petitioner thereafter preferred WPC 7327 of 2015,
2015.
by which this court
23
had
2000.
observed that the finding that the reason for rejecting the claim of the petitioner for provincialization as a drop teacher by the High Power Committee being only that his name was not found to be included in the detailed particulars submitted at the time of provincialization of the school was not ground enough to have refused to consider him as a drop teacher. Full stop. The communication which had given
In
the
February
which had made known the aforesaid communication was set aside, and the matter was remanded back to the respondent authorities to consider the case of the petitioner for provincialization as a drop teacher. And in doing so, appropriate reasons thereof is stated either for accepting or rejecting such claim.
Then
The
Annex
matter was again placed before the High Power Committee
73,
and by the recommendation dated 13th of
27.
February. Huh?
77 page.
We are at page 73, madam.
Oh, yes, yes.
Let us
73,
dictate the order.
later dated.
Or we can ask you to put in the facts and we will give the decision later. No. Okay. By the recommendation dated 13th of February 2020, the committee recommended the petitioner's name for regularization of services. Full stop. The relevant portion of the recommendation can be found at your name is serial number 6 of the recommendations made on of the minutes of the High Power Committee meeting held on 13/11/2019. Full stop. The matter was therefore forwarded to the government for taking an appropriate decision on the recommendation. And by the impugned order dated 18/4/2023, the Secretary of the Government of Assam rejected the claim for regularization or provincialization. Full stop. The relevant portion of the order is quoted below for a ready reference. You will take from page 90 A to A. Huh? Okay. This is the order which is now challenged in this petition. Next paragraph. Ms. KDB Learned Counsel for the petitioner has submitted that there is no dispute taken by the respondent authorities that the petitioner was in fact appointed on. What was the date, madam? Appointed on 15/1/1988 by the authorities of the school prior to the provincialization of this. It is the approval which was granted in the year 1992. Stop. The provisions of law relevant for the purposes of taking over the teachers in a venture school required that such teachers should have put in at least 2 years of continuous service immediately preceding the taking over of the school. The Learned Counsel for the petitioner has submitted that the impugned order does not reflect that there was any finding recorded that the petitioner had not been in continuous service of the school prior to the date on which the petitioner the services of other serving teachers in the school had been taken over by the government. The Learned Counsel for the petitioner has also drawn attention of this court to the undisputed appointment letter and the undisputed approval granted by the competent authority at the relevant point of time, both of which reflect that the petitioner had indeed been appointed prior to 15/1/1988. In fact, it is, the Learned Counsel for the petitioner argues, that the very approval given in the year 1992 would show that the petitioner had been continuously serving in the school from 15/1/1988. Otherwise, the approval would not have been granted in the manner in which it was done. Full stop. The Learned Counsel for the petitioner submits that the ground given in the order dated 18/4/2023, by which presumptions were drawn that the approval being granted on 10/1/1992 was the reason why the earlier High Park Committee in its minute dated 22/12/2014 had rejected the claim of the petitioner, comma, is unconceivable in law, since the minutes of the aforesaid High Park Committee meeting itself did not reflect such a finding, full stop. She therefore praised that the petitioner would be entitled to be given the benefits given to other similarly situated teachers whose services were taken over by the government at the time of in 1991. Full stop. Mr. B. Talukdar, Learned Counsel appearing for the Education Department, has submitted that prior to coming to a finding by the Secretary to the Government of Assam, comma, the Department of School Education had constituted a committee to verify the records pertaining to the matter, and accordingly a hearing was concluded. There are specific findings in the order dated 8/4/2023, where the petitioner could not produce authentic documents in support of the fact that the required approval of the name of the petitioner was received before 1991. He therefore submits that when the approval was received after the provincialization of the school, the case of the petitioner does not require any further consideration or adjudication by this court and deserves to be dismissed. Full stop. I've heard the Learned Counsel appearing for the parties. It is not in dispute that the petitioner was appointed in the year was appointed by the order dated 15/1/1988. It is not in dispute that the concerned competent authority at that relevant point of time had afforded approval of the appointment of the petitioner in the particular school, although in the year 1992, but without recording any finding that the petitioner was not found to be serving in the school. The different documents which have been annexed to the writ petition and which have not been specifically denied or contested by the respondent authorities would also show that the authorities at the field level had given conscious certificates to the effect that the petitioner's name had been dropped from the detailed particulars, although his appointment and his service in the school were not disputed by any of the authorities. We therefore find force in the argument of the Learned Counsel for the petitioner that the petitioner being appointed on 15/1/1988 had a legitimate right under the appropriate provision of law, that is the so-and-so Act of 1977, to have her services taken over by the government in an appropriate manner when services of the colleagues of the petitioner were taken over. Full stop. With regard to the contention raised by Mr. Talukdar that the petitioner or the concerned stakeholders could not produce any document in support of the fact that the approval of the name of the petitioner for appointment was delivered prior to 1991. We do not, this court fails to see as to how the said contention could be of any benefit to the, could be of any relevance to negate the claim of the petitioner. Full stop. The relevant law requires that the petitioner must have served in the school for a period of 2 years before the school was taken over. Full stop. The appointment letters and the documents which gave approval to such appointment are documents only to substantiate the date of appointment and the date of approval. Full stop. The respondent authorities, now, when the respondent authorities have not for once contested or relied upon a not relied upon, you write like this. When the respondent authorities have not taken the ground that the petitioner was not found to be in service, in continuous service prior to 2 years of the school, of the services of other colleagues having been taken over, comma, as has been held in the earlier round of litigation in WPC number 7327 of 2015, disposed upon 23/4/2018. This court also holds that such a submission made at the bar during hearing of the petition without being supported by the impugned order itself, has to be heard only to be rejected, full stop. In view of the findings recorded herein above, this court is of the view that the rejection of the petitioner for taking over of his, the rejection of the prayer of the petitioner for taking over of his services under the Act of 1977, as had been done for his other colleagues in the year 1991, deserves a interference of this court, full stop. The matter has been pending. The litigations between the contesting parties have been having been carried out for more than 20 years till now. What was the first date of your repetition? The first repetition that you had preferred? Your first repetition, 2005? Oh.
Pursuit petition.
13 and
3976.
more than 12 years now.
Yes.
And the right of the petitioner to have been considered for his services being taken over by the government, having accrued to him in the year 1991, this court does not deem it appropriate to remand the matter back further again to the department to take a decision, full stop. It is noticed that the department has, full stop. In the circumstances, this petition is disposed of directing the Secretary to the Government of Assam, Department of School Education, to issue appropriate orders effectuating the taking over of the services of the petitioner in the what school? What school?
Bhogpur ME Madrasa.
Huh?
Bhogpur ME Madrasa.
Bhogpur or Gopur? Bhogpur.
Bhogpur.
Bhogpur ME Madrasa.
BHOG.
That you will find at page 29, huh? Bhogpur ME Madrasa with effect from the same date that the services of other colleagues of the petitioner had been taken over. Full stop. The respondents, however, would be at liberty to ascertain the continuity of the service of the petitioner. The respondents would, however, be at liberty to ascertain as to whether the petitioner had been continuously rendering his services the aforesaid school from 1991 onwards for determining the actual area of salary required to be paid to the petitioner in case he has actually rendered services. Full stop. It is clarified that in any case, the petitioner, the salary of the pay and salary of the petitioner shall be calculated notionally. Full stop. Notionally, at any rate, full stop. At any in any case, full stop. The petitioner shall be paid his salary if he continues to serve in the school. The petitioner shall be entitled to be paid his don't write it. Write it like this: the respondent shall pay the salary to the petitioner for his services being rendered, if any, immediately from the date of this order, and continue to do so till he and continue to do so unless there is any impediment created by law in the future. Full stop. The area salary, if any, for the petitioner shall be paid to him within a period of 6 months. Okay, full stop. The petition is accordingly disposed of. Full stop. List this matter again. No, register to list this matter again. 6 months. 1 month, March, April, May, June, July, August, September. in the month of October, along with a compliance affidavit to be filed by the committee to the format of. Did we say that? Should be asked for a compliance affidavit.
Or my lord, may we dispose of the matter?
Yes, from the month of March, we will dispose of matters, have them listed after 6 months for compliance.
Yes.
No sleeping over the matter, waiting for the petitioner to come back to the
In the
court.
meantime,
line.
you will also retire, my lord.
Huh?
In the meantime, he is also
Going
retired.
to
my lord.
be retired this year also.
Then
Last part of.
the last part you cut out, huh? Writ petition accordingly is disposed of. Yes. Thank you.
And your
Right.
place. You look.
Eta time being এটা কইলো Mr. Goswami, 2 or 3 time being matters are there. Thereafter, we'll take yours. You have your instruction, madam?
Instruction is lordship, yes, lordship. This is already their lordship. His case has already been considered lordship in the DLC meeting. And he is claiming that 1/6/2015 notification is applicable to him. So he must be, that means his case to be considered on that lordship. The date of admittedly it's of 2013 lordship, 2013.
Even then, it's 12 years down the line.
Lordship and lordship, the recent notification and executive order lordship,
We'll have it on 18th.
18th lordship.
None appears for the petitioner on call. List again on the 18th of February 2026.
We are not filing any affidavit lordship here.
Yes, sir.
So I had communicated with the petitioner. She is agreeable to if she can be considered in the subsequent DPCs. Is that matter wherein lordship, the promotion was not considered?
No one is here for the respondent. We'll take it up after some time again.
Right.
Time being.
Lordship, vacancy position. Lordship.
Yes, come.
Mine. Dada. Hey, Google.
Tell us the dates.
Lordship,
Miss.
Miss D. Bora, on behalf of Mr. B.M. Dekha, Lordship.
Huh?
On behalf of Mr. B.M. Dekha, Lordship.
Miss so and so. Also heard. Sir?
The Taluga.
Learned Counsel for the petitioner has submitted that the petitioner is
Social justice 3. Social justice 2 and 3.
a person suffering from the benchmark disability
I am from 4.
as defined in section 2R of the Right of Persons with Disabilities Act 2016 and is orthopedically handicapped with 45% disability. The petitioner also belongs to the Scheduled Tribes Plains Committee, which is entitled to the benefits of reservation of posts in state-sponsored vacancies. By referring to, where is the interview letter, madam?
Interview Lordship 2005.
Huh?
Annex 3 Lordship.
Next at 3, page 24.
Interview letter
Page 24 Lordship, type copy.
by referring to the call letter calling the petitioner for interview by the district level selection committee constituted for recruitment of person with disabilities for an oral interview which was issued on 2nd of September 2025 for filling up backlog vacancies in grade 3 and grade 4 posts, comma, the petitioner had responded to the said advertisement and participated in the selection process. Learned Counsel for the petitioner submits that there is no dispute to the aforesaid fact. Thereafter, what happened, madam?
Lordship, interview was conducted on 15/9/2005.
The interview was conducted on 15/9/2005.
2005.
Stop. Were you a part of the writ petition, which is there at page number 26?
The order of the High Court.
I
Lordship.
thought, yes, were you a part of the writ petition? No.
Yes, Lordship.
Which one are you?
Lordship, in the Bhupen Bhuiya and 105 others, Lordship.
And? Acha.
Was
The petitioner thereafter, along with some other candidates, had preferred WPC 1424 of 2011, which came to be disposed of on 23/4/2015. Wherein this court had directed as follows at page 37 from A. When the appointment process regarding the petitioner had not been had not materialized, comma, the petitioner has filed the present writ petition paying for appropriate directions. Full stop. The Learned Counsel for the petitioner has referred to the communication dated 13th of September 2019 available at page available as annexure 7 petition to show that to submit that the contents of the aforesaid letter were probably the reason for the delay in affording an appointment to the petitioner, although she was an selected candidate. The letter dated 13/9/2019 reflects that the Deputy Secretary to the Government of Assam Social Welfare Department, Dispur, had been informed by the informed the Joint Secretary of the Government of Assam Elementary Education Department that the name of the petitioner was not found in the list prepared by the Director of Social Welfare and countersigned by the Joint Secretary to the Elementary Education Department. The Learned Counsel for the petitioner submits that once the petitioner had participated in a selection process and had not been rejected in the same, a right accrued in her favor to be considered and offered appointment to a grade 4 post as may be available in the relevant department. Full stop. The affidavit in opposition filed by the Secretary to the Government of Assam, who was arrayed as respondent number 4, has stated that has stated as follows from page 52 E to B. The learned counsel for the petitioner submits that in view of the admission made by the respondent department, the petitioner has been confirmed to be one of the 100 eligible petitioners covered by the orders passed in WPC number 1424/2011 and other connected writ petition. She further submits that since the government in the elementary education department, within bracket likhibo now, the Department of School Education has already directed the Director of Elementary Education some to furnish a vacancy position to the government at the earliest, the case of the petitioner is undeniably required to be considered in the positive and appropriate directions may be issued to the respondent authorities offer immediate appointment to the petitioner. Mr. B. Talukdar, learned counsel appearing for the Education Department, has submitted that the contents of the affidavit reveal the factual position, and today he has also produced an instruction to the effect on an instruction showing the total number of existing vacancies in Bongaigaon district to be 7. Full stop. The instruction reflects that these posts do not include posts already approved by SIU, though yet to be filled up. Full stop. The instruction also reflects that the 7 posts are non-planned posts with the duties and functions of an office peon and are essential to be filled up by direct recruitment. Full stop. We have heard the learned counsel for the parties and we have perused the records made available through the writ petition and the affidavit in opposition and also the instruction placed before us, which is retained in the record by marking the same as X. Full stop. Since there is no dispute at the present that the petitioner is one of the recommended candidates who was required to be appointed on the ground of physical disability and who also belongs to the ST category, and also keeping in view the fact that there are presently vacancies available for appointing the petitioner, this court directs the concerned authorities in the Education Department, more specifically the respondent number 2 and 3, to take up immediate, not 2 and 3, respondent number 6 and 1, to take up immediate steps. Is it respondent number 6 and 1, madam?
6, my lord, Director Elementary, 1 is social welfare, social justice.
And you are for social justice. And what will you do now once you have sent the list? What will you do now? You will do nothing. Huh? Is it 6 and 1 who will do the appointment process?
Yes, Lordship,
Yes.
6 and 1.
Don't prompt. No prompting. Respondent number 6 and 1 to take immediate steps to finalize the appointment of the petitioner, to stop the process for appointment of the petitioner, including achieving approvals from any concerned departments, shall invariably be completed within a period of
3 months.
Huh?
3 months.
My lord, it's ranging from 2015.
And March 2026 is coming on. Approvals will be late.
And my lord, the election.
Within the Let it be a Bihu gift within the 11th of, 10th of March, 10th of April, 2026, Bihu gift. 10th of April, 2026, full stop. The writ petition shall again, 26, full stop. The respondent number 1 shall file a compliance report in the matter before the registry of the court in connection with this writ petition on or before 24th of April 2026. In case the compliance report is filed as directed, no further action on this present writ petition is required to be taken. However, if the compliance report is not brought on record by the aforesaid date, the registry would relist this matter again on April on 30th of April 2026. Writ petition is disposed of.
Much obliged.
Petitioner shall appear in petitioner shall supply a certified copy of this order to the office of the respondent number 1 and 6 within a period of 1 week from today.
What's up?
If the compliance report is not there, relisting.
All right.
Yes.
Lordship, here in the earlier writ petition, your lordship had appeared, your lordship. Your lordship had taken notice also.
I cannot detect it, sorry.
List before a bench without me. Just
Obliged, sir.
upgrade it. Upgrade it.
My lord, I'm praying for time until Monday, my lord, to get instructions in this matter.
Last occasion it was you, let this occasion be his. Tribal Thakur, Learned Council appearing for the respondent has prayed that the matter may be taken up on the 9th of February. Learned Council for the petitioner has consented. List again on the 9th of February. Yes, sir.
This interlocutory application has been preferred in the review applications to bring into the for correction. In fact, before that, may I draw your attention that page 14 of the IA.
Page
this
14,
order, 14 May 2013, by this order, the school of the petitioner school was provincialized and with effect from 1/1/2013.
1/1/2013, yes.
There is bias anomalies are there. That is why the benefit was not given to the petitioner. That is why the petitioner approached this honorable court.
But the order of provincialization was there. Benefits were not being granted.
Not
okay, then?
Then we approached this honorable court. Unfortunately, the writ petition was disposed of. Relevant person is at start from 19 page. On that 12/12/2019, we could not before the honorable court because the car one was there. But the ex parte order was passed. I just pointed out, order was passed and it was disposed of. Its operative portion is at paragraph 12, page 23. Accordingly, the court direct the authority to examine the affairs. The case of the petitioner, keeping in mind the provincialization order, has not been recalled, and cause the school to rectify deficiency if there will be any, and accordingly extend the period of the provincialization with prospective effect. In terms of the provincialization act, so and so 17. The school was provincialized under the provincialization act of 2011 amended at 2012. So we accordingly approached this honorable court by review. Annex 3 is the review ballot order, and relevant portion is at page 27. That is
read it. Yes.
there also the prospective effect,
That
well,
sentence came in,
it
yes.
is advertently made, Malad. Accordingly, pursuant to this order,
Ah.
the director give this, speaking orders was passed.
Mm.
On the same line, my lord, page 29, my lord, see, there are 5 column, my lord. 29E, my lord, sorry. Prospective effect was mentioned, 5 period, my lord. So unfortunately, my lord, due to this, my lord, we could not, my lord, get the benefit. My lord, I file a additional affidavit to bring into record a judgment of this honorable court. Your lordships distinctly remember that review application filed by the state. My lord,
What is
that-
what is the I for? To correct, to
correct
review
the prospective to the.
Yes, who appears for the department? Yes, tell us. Judgment already set aside, act already set aside.
My lord,
There can be no prospective effect to it. Is it?
my lord.
Now, he was already granted the provincialization under the old act.
My lord.
You do not dispute that. Court says, in a review, the court says, okay, under the 2011 Act, if everything was okay, give him the benefits. You do not challenge that. The court said under the 2017 Act by mistake.
My lord.
Realizing the same, the court modifies the order, saying not 2017, make it 2011, please. Read it as 2011. Because they were already had a provincialization order, we have to see whether it is correct or not.
My lord.
Done? The word prospective crept into at page 27. The word should have been with consequential benefit. It became with prospective benefit. But there is one problem, sir. When the, okay, there must be some difficulty. Yes, what do you say?
Lordship, today actually I'm handicapped.
Is Mr. P.K. Bora available in the court today?
My lord, he's not available. That's what, my lord. So I'm seeking for some accommodation today, my lord.
Like, my lord, one of the person has already been retired, my lord, so, my lord, that is why I mention it at to my lord.
This needs to be allowed.
Yes, some accommodation.
Do you have any ground not to, in law? In facts, it would have been otherwise. The facts are clear. 2011, there was already a order for provincialization. It was not in the pipeline.
My lord.
Orders were passed. Dias code mismatch. All other schools where the Dias code mismatch was there, they have the benefit from 13 onwards. We have not come across any case where we were informed that there is an appeal to that part of the order. This school remains up. Yes, heard Mr. So-and-so Learned Council appealing for the applicant. So heard Mr. So-and-so Learned Council appealing for the education
Elementary
department. The by this interlocutory application, prayer has been made for the correction of the word with prospective effect appearing at paragraph 8 of the order dated 7/12/2020 passed in review petition number 67 of 2020. List of the Learned Council for the applicant has submitted that although in the first instance, while disposing of WPC, the connected WPC 390 of 2018, his court had directed a consideration of the case of the petitioners under the what act? Long act. Assam Education, Provincialization of Service of Teachers and Reorganization of Act 2017, on a review, keeping in view the fact that the petitioners were required to be given the benefit of provincialization under the Assam Venture Educational Institution within bracket Provincialization of Services Act 2011 as amended in 2012, had modified the order dated 12/12/2009 thereby giving the benefit of provincialization under the Act of 2011 as amended in 12 to the petitioners herein full stop. However, inadvertently, but it appears in two places. Can you have a look at paragraph 5? It was your submission. It was your submission. You wanted it prospect. Court gave it prospectively.
No, my lord, that was definitely hurriedly, our submission definitely with effect from 1/1/2013. Because act was inadvertently mentioned in the petition,
Okay.
writ petition order.
This court has gone through the contents of the interlocutory application and has also looked at the earlier orders of the court. Mr. A. Fukon Learned Counsel appearing for the respondents has prayed for an accommodation to be allowed to call Mr. A. Bora, who had originally appeared in the review petition. This review petition has, this interlocutory application has been pending from the year 2023 onwards. And the respondents have not filed any reply to the same. In such view of the matter, this court is not inclined to grant further time to the respondents to file any affidavit or file any affidavit. Full stop. Having gone through the earlier orders passed by this court in the WPC and in the review petition, this court is of the opinion that the words appearing at paragraph number 12 of paragraph number 8 of the review petition of the order dated so-and-so passed in the review petition with prospective effect, inverted commas or the requires to be substituted by the word with consequential benefits. Accordingly, it is directed that the order dated 12/12/2019 passed in the WPC number so-and-so as corrected by the order dated 7/12/2020 passed in review petition number so-and-so shall now read as page 27 IA para 8 of A to A disu shall now be read as to to copy koriboy ate yellow with prospective effect likha ase with prospective effect jagat with consequential benefits kori dibo.
Highly applicable.
Interlocutory application accordingly disposed of. Start filing affidavits. Yes. Yeah.
May I please, Your Lordship? Your Lordship may kindly peruse the last order. Record of the.
Where is the inquiry report?
Inquiry report, Your Lordship, I have not been furnished.
You have not been furnished.
Not.
Yes, no furnished.
Inquiry report not furnished, Your Lordship.
Lordship,
In
what
the
happened,
hearing on the very first day, my statement was recorded. Thereafter, what happened, I don't know, Your Lordship. Nothing, Your Lordship.
One fine morning, you have an order of
This,
penalty.
Lordship.
Lordship, what happened, Lordship? In this case, so-called notice was issued.
That is our question. What happened?
Lordship, I'm telling you, Lordship. So-called notice was issued with list of documents, list of everything. Inquiry officer was appointed. On the next day, Lordship, one date was fixed for hearing, inviting all the stakeholders in the meeting. On the fine day, Lordship, and inquiry report was submitted. After hearing was completed in the morning, and report was furnished, and on the basis of report was sent to the government. And
Do you have the copy of the inquiry report? Kindly let us have it. We are going to pass orders to the effect that this person will not be allowed to be the presiding officer in any inquiries hereinafter.
I have full the order, but this is
He does not know the procedure. He should not be given those duties. And also the disciplinary authority should not be allowed, something like that.
Lordship 54.
Means he does not know what to do.
Yes.
When an inquiry report is not furnished to the, let him not pass orders on disciplinary proceedings. Let it be sent to the state inquiry officer. They would do a better job.
Lordship, page
From when is it pending? 2020?
Page 54, Lordship, may kind.
Page?
54.
No, I'm not being able to trace up page 54.
Lordship, that is the inquiry.
Where is the charge sheet?
Page, get page 5. T. 5C, Lordship. Last. I have
Page
checked.
five, you are hereby required to show cause.
Yes, Lordship. 23rd, 12, 2020.
Allegation is of manipulation.
Lordship. Of date of joining. According to Lordship petitioner, his date of joining 10/10 to 1990. And according to department, he joining 5/12/2019-91, Lordship. And in the inquiry report, this like a fact finding report, Lordship. Nothing, initially it was like proceeded, like disciplinary proceeding. But at the end of the day, it's turned to a fact finding report, Lordship.
Assam discipline and appeals, that is what you followed?
Yes, Lordship.
Assam discipline and appeals from. Can do more quickly, Paribu. Heard Mr. S. Bothagur.
One aspect I have need to say, Lordship. For that, Lordship, it was vitiated from the stage of filing report, Lordship. So, instead of setting aside entire proceedings,
We'll allow you to
they
do
allow
a de
you
novo-
to proceeding
we will
from the
leave
stage.
it to you to do a de novo proceeding.
Further inquiry, Lordship, from that stage, where from that further proceeding, from that
Once he has
stage,
disclosed everything,
no.
his statement has been recorded.
Yes,
His-
my
kindly,
statement has been recorded.
Without giving him the prosecution,
Lordship,
he had to have his defense witness recorded.
Lordship, his statement was recorded like, his statement is like that so-called reply. Yes, Lordship, his
Whatever
statement was
be it.
recorded,
Whatever be it,
Lordship.
the predetermined mind of the department to impose the penalty, where does it go?
That will go, but for that, Lordship,
There are two things, sir.
Lordship,
One is the non-compliance of the
Rule 9.
rules and the violation of principles of
Natural
natural justice. Done in a manner where this court thinks could have been an error which can be corrected in law now is one part of it.
Lordship.
Done in a manner which violates the written down procedure in the appeal, in the rules itself.
Lordship.
Complete go by to everything in the rules.
It is correct.
Do we see a malice in law? Would it be a malice in law?
Yes.
It would be.
Yes.
If so, these are not the persons to hold the inquiry.
Maybe by,
Maybe refer to the State Inquiry Commission who may like to take up an inquiry.
Yes,
But
Lordship.
not these persons.
with that liberty, Lordship.
If they do not know how to hold an inquiry, I don't think they should be.
Allegation, whatever with the truthfulness, I am not commenting.
Ah.
Allegation is serious. That manipulation of that.
The inquiry, if any required to be proceeded under the charge sheet,
Lordship.
shall be done by an authority to which the persons who were attached in this inquiry will not be a part of.
Lordship. Lordship may observe. Lordship.
Yes, Mr. Bothagur.
Lordship, two things I just want to point out before your Lordship go on. Your Lordship may kindly come to page 80.
80
80.
of the writ petition.
No read petition. only. By this
Just a
order.
minute, let me flag the relevant pages in the
Lord.
record file.
Lordship. Lordship, initially page 5, Lordship, it is focus notice.
The show cause, I will tell you another big issue here. Page 5 at the top, it is written draft.
Lordship, in the pre-page, Lordship may be there. Pre-page or post-page.
This tragedy of it.
That type of.
Yes. Just a minute. It is not page 5.
Yes. In actually, original.
Immediately
there is
after
no
page 5,
marking.
unnumbered.
Unnumbered, that's why I mark it page 5. It was
Or-
maintained like before, Lordship.
Our mistake, but you see that page 5 is not
Yes, yes.
followed by the statement of allegation. or the
Yes, sir.
list of documents of list of witnesses. Did you get them? The statement of allegation, list of document, list of witnesses,
Statement of allegation is there, Your Lordship.
list of documents and witnesses.
List of documents,
It is
name, they have mentioned it.
It is a list.
List.
It is not document.
No comment. Your Lordship, what is there? I have submitted a
For
representation.
inspection.
Inspection, they did not allow me.
No, allow. He has, there is endorsement, Lordship. There is an endorsement, his
What we
signature.
will do is, even if allowed or not allowed, we are not setting aside the show cause notice because it has allegations which may require inquiry. But
Lordship,
an inquiry in a fair and proper manner,
Lordship,
looking in the manner in which the earlier inquiry had been conducted,
Lordship.
none of the persons associated with the earlier inquiry shall be associated with a inquiry proposed to be continued under the original charge sheet. We'll give them a time frame. Kindly cooperate. Any delay on the part of the petitioner,
Lordship,
we'll give them the handle to take extended time.
Lordship.
If not completed within a specific period of time, we'll zip up the matter.
Lordship.
Lordship, two orders, Your Lordship, I want to place before this honorable court, before that. Page 80, Your Lordship.
No, he was showing something else.
Lordship, that in the record, Lordship would find in page 7 that letter dated 21/2021 filed by the petitioner for inspection of document.
Yes.
And letter dated 8/3/2021, page CL8, Lordship, CL number 8, there, and allowing inspection on 23/3/2021, Lordship, the blue flag. And thereafter, reply to the show cause notice, he has filed a reply on 12/4/2021, page 21.
12/4/21.
The green flag, Lordship.
Yes.
Green
This
flag
is the
item.
reply.
Yes, Lordship.
Reply to show cause. Very well.
Reply. Then order pass, Lordship, page 22, that yellow flag, Lordship would find 17/21. Appointment of enquiry officer and president.
Just a minute.
That yellow flag, Lordship.
Yellow flag. Yes.
Yes, 17/21 order. Appointing of enquiry officer and presenting officer, Lordship. Thereafter, notice of hearing dated 18/9/2021, Lordship. Page 23rd, Lordship.
Yes, you are required to attend.
On hearing of speaks on 24/9/21. Thereafter, Lordship, statement of Mohendranath Datta, Lordship, page 31.
Just a minute. 24/9/2021, he was required to be present.
Yes, Lordship.
Then
Thereafter, Lordship, statement of Mohendranath Datta, sir, recorded page 31.
on 24/9/2021.
21, yes.
Just a minute. No, this is
Page 31.
Sandhya Rani Som.
Yes. And statement of
No, this is Sandhya Rani Som. We find who's
Lordship,
the other
page-
statement?
page 31, Lordship.
Page 31.
31, 31. T1, Lordship.
Okay.
Mohendranath Datta. And page 37, Lordship would find the statement of petitioner, Arun Kumar Barua, Lordship, Amal Kumar Barua. And IS also submitted report, page 51.
Page 51 is
Is the report of the inspector of school, Jorhat district Shakur, Lordship. Report
Just a
dated
minute, just a
23rd
minute,
9
just a
to
minute.
21.
Then
Then, Lordship, enquiry report, page 54.
what does the enquiry report say? Let me take a read.
On the very day, statement of all person present have recorded and arrive at a conclusion, Lordship, that petitioner has manipulated his state of joining, Lordship.
The pendency of litigation in different courts should be so benefited
Yes.
if such up and doing people were there with us.
Thereafter, Lordship, enquiry report was accepted as page 15 note sheet.
Huh?
In note sheet, Lordship.
This came from,
From note sheet, page 15,
this was submitted when?
on 34/2022.
Does
So
not
it
even
was,
have a
it
date.
was accepted, enquiry report.
No, it does not even have a date.
Yes,
Where is the date in this enquiry report?
enquiry, there is no date, Lordship. But enquiry report acceptance, note to Lordship would find it page 15 of the note sheet.
Note sheet.
Note sheet. Dated Lordship 34/22. 15 page.
3422.
Enquiry report acceptance report.
No.
There is also
At page 14,
no Lordship 1.
enquiry report of DP
Lordship, yes.
may perhaps be submitted to the Honorable DSC for necessary approval.
Approval, Lordship.
So now
Lordship.
the enquiry report is being sent up by the enquiry officer to the
Yes.
disciplinary authority for approval.
Approval. And that approval perhaps Lordship page 15.
No, should the disciplinary authority be approving the enquiry report?
Acceptance.
From
of
where
the-
do these people get these ideas? Very sorry state of affairs. And they, and authority is there to terminate, to promote, to appoint.
On 34/22, that enquiry report was accepted by the competent disciplinary authority.
And then the report is accepted.
Accepted, Lordship, page 15.
And it does not say that the copy was given to the petitioner.
And on 3/6/22, that report was sent to the government for cancellation of appointment
Of whom?
to Secretary Lordship by
No, cancellation of appointment of whom?
petitioner.
As headmaster, Your
As
Lordship.
headmaster.
And they acted upon. I put that to challenge. This honorable court in the connected writ petition state that order, Your Lordship. And Your Lordship will see, Your Lordship, on page, that's what I wanted to show this honorable court. Page 80, Your Lordship may kindly come to my. This honorable court directed the authorities to reinstate me, Your Lordship. Page 81, Your Lordship, the relevant paragraph. Accordingly, impugn order of suspension of the petitioner under so and so issued by the director of
That
secondary.
is a reinstatement.
Lordship.
You are placed under suspension.
Suspension.
Are you ready with the dates? Once we start to dictate, are you
Lordship,
ready with the
Lordship,
dates?
I'm ready. Then,
Mr. Dutta?
then Your Lordship will kindly see, after this order, they pass page 82 order. This is, with reference to the subject cited above, I am directly inform you that Government of Assam, Department of School Education has approved your proposal for cancellation of promotion. Order in
Now, if
respect
the
of,
promotion is cancelled, what was required to be done?
You will have
To
serve as
become a
assistant
what?
teacher.
Huh?
Assistant teacher, Lordship.
I will, now Your Lordship, that order I put to challenge in page 83. And the honorable court
Has stayed it.
stayed it and has said the director of secondary education Assam is directed to show cause as to why his action in demoting the petitioner from headmaster to assistant teacher shall not be construed as an act of
Any
overreaching the
affidavit
order.
filed in that writ petition, the other writ petition?
They have not filed any affidavit, Your Lords.
The show cause has not been given.
Lords.
Suo moto contem.
And this order, Your Lordship, which was, Your Lordship, dated, the impugn order, which was dated 8/11/2023, served on me, Your Lordship, 9/7/2024, Your Lordship.
Which one? Which order?
Last impugn order, Your Lordship, by which, Your Lordship, departmental proceeding was closed, page 88, Your Lordship.
Page 88.
This is the impugn order by which departmental proceeding was closed.
Then you see after the enquiry report has been submitted, Mr. Dutta, page 89. Come to page 89. Top line. Whereas a report has been obtained from the inspector of school Jorhat. He was a witness there.
Yes.
The proceeding. After the enquiry report, One more report is called for. This is behind the back of the
No.
petitioner, is it not?
Yes. Earlier report of inspector was 23rd of September 2021.
Now for
Earlier report, now Lordship 4/11/23.
No, we are not on that.
Yes, yes.
We are on two things. One, the same witness is again allowed to put forth his evidence.
No, that report, Lordship, my humble submission,
Ah,
was only in respect of that holding of the post, that present status, the then status of that post, Lordship. That which said that the post of assistant teacher of Janata High School, Jorhat, that was held by Amal Krishna Bora before promotion, has been filled up, and therefore the inspector of school in his said report proposed another post of graduate teacher lying vacant.
okay, okay.
That's why he was accommodated.
I read half the sentence, fine. This order of your motion and other places under stay,
Yes, sir, that was said in this
can you
second.
continue to be the headmaster?
No, your lordship, they have not put me in charge of the headmaster. I am hanging, your lordship, right now. I am getting
If it was-
salary,
if
but
it was suspended, where is he working?
He was now reinstated, Lordship, at National Telegraph Girls High School under SM district.
He has not joined there because there is a stay.
stay, lord.
Order dated 16/7/2024. You are drawing your salaries from?
That school, your lordship, as an assistant teacher, your lordship.
From Telegraph School.
Lords.
You
In
are
fact,
serving there, you have joined there.
no, your lordship, I mean, 1%. We have not.
Then how are you drawing your salaries?
I don't know, your lordship. I have been instructed that your lordship has, and in fact, your lordship, what he has been
Ah,
asking, your lordship, that he want to join, your lordship. Ultimately, that's.
where?
No, he is in original post since there is an order by this honorable court.
He
Your,
wants to join in back in the headmaster's post.
yes, your lordship, because your lordship, honorable court has
Mr.
already
Doctor,
directed for my reinstatement.
This is just for the relief that we are trying to discuss now. The headmaster, the disciplinary proceeding having gone, let's see. He set us, if he set aside the disciplinary proceeding, then the impugned order has to go. Impugned order has to go, then the status quo ante has to come back. He joins back as the headmaster. You have given him a charge sheet. Allegations are serious. You have to act on the same charge sheet.
No, not.
He will have access to everything all the time.
The documents has already been seized, your lordship.
Profitable for you to have it started again from the same charge sheet.
Otherwise, Lordship, that allegation has to be inquired into.
Your
The
lordship,
manner in which the inquiry proceeding
Yes,
has
sir.
been initiated, everything goes.
Lordship.
Yes, sir.
lordship, one paragraph, one line, your lordship, that is your lordship, page 1110, your lordship. This is a letter by the director, your lordship, to the secretary of the Govt of Assam, your lordship. Page 110, your lordship, it starts from. And your lordship will kindly come to page 111, your lordship. What is what they have found, your lordship? I mean, just to show, your lordship. Janata High School District, Jorhat was provincialized on 1911-91. Before provincialization of Janata High School, Amal Kumar Borua BSc Royal was allowed to take classes of secretary of the sage by the secretary of the sage school. Vice Parag Bora resigned on 9/10/1990. But no formal appointment letter in respect of Amal Kumar Borua issued by the school managing committee of the Deed and Janata High School is found on record, your lordship. It is not that, your lordship, I was not there. What they did not found, your lordship, is the appointment order. It is the director herself says, your lordship.
That is the story.
Lordship. Now, your
Joined
lordship,
without
based,
an appointment letter. He joined without an appointment letter, continued to do so. In the statement, the headmaster said 5/2/1991 because 1/1/1991 provincialization, all that thing came into being.
lordship.
And
That was at Bhansar stage, your lordship.
even if it is an overwriting, there is a reason for it. He joined on 10/10/91, formally appointed later on. So date of joining he understood as should be so and so, even if he is overwritten.
Still, I am ready to face the inquiry, Your Lordship. If Lordship wants to, Your Lordship, give them a
We are
liberty.
also bound by law to some
Lo-
extent. They
Lordship.
have to come to their own
Lordship,
conclusion.
since it
And
is
only-
on merit, Your Lordship, I have not pointed out initially, but the thing is, Your Lordship, the very process of initiation of the inquiry itself is, Your Lordship, is less with malice, Your Lordship.
You have understood the case, we'll record your presence.
Lord.
We are keeping the court here.
Lordship,
We'll try to take it up before the court rises
Lordship,
as early as possible. Let me finish the other matters. If
Lord.
it's detailed in this matter, everybody else has to wait.
Lordship.
We'll try to finish as many.
Lord.
If we cannot take up the matter for disposal today, we keep it for yes. Friday,
Lord.
Saturday.
Lordship, Monday,
Event,
Monday, Lordship.
it's working day.
Saturday, Your Lordship, I will be out of station, Your Lordship. Yes.
So your assistance is enough. He can
Lord.
assist.
Lordship,
He can assist.
Lordship, yeah.
I need to hear your Lordship dictation. I will be out of station.
This is it there, Your Lordship. Virtual mode is there.
You need to hear me. Like I need to hear you only. Yes. If it doesn't, if we cannot reach it, we'll fix a date for delivery of orders.
Lordship, Lordship.
Otherwise, we'll try to dispose
Lord.
of, declare the order today in the court itself. এতিয়া থাকক এতিয়া থাকক এতিয়া থাকক কোর্ট যদি শেষ হয়ে দেখা যাবে
Lordship,
কোর্ট
one
শেষ
thing-
মতে দেখা যাবে
One thing I'm just clarifying that earlier to that, Lordship, one explanation was issued 6/9/2013, 8/70.
That is prior to
On the
suspension.
last, on the last order, that order letter was reflected. That's why I'm clarifying. That was the explanation. On the basis of that, he has submitted his reply. And after
the
that,
show
there
cause
is
notice
no
comes.
Then so called.
That is the mistake when you call it a show cause notice.
Yes, that was not a so-called, that was an explanation.
No. Show cause as to why a proceeding should not be initiated against you.
Yes,
So he replies, you are not satisfied.
yes,
You initiate the proceedings.
yes,
While initiating the proceedings, you level charges, you don't give a show cause.
yes, memorandum of.
Memorandum
It
of.
will be a memorandum. Show cause will again come when the inquiry report should not be accepted.
Lordship,
Then you show cause why we should not take up the inquiry report itself. The language itself
yes.
creates a lot of confusion. Yes, we'll take it up, we'll try to take it up for dictation, end of the board.
Deeply obliged, Your Lordship.
Ask your assisting counsels to have
Lord.
some judgments ready.
Lordship, judgments are
You
there.
don't need to.
Lord.
Okay.
Lord.
Yes, madam.
In this case, my lord, relates to arrears salary, releasing of arrears salary, my lord,
Huh?
releasing of arrears salaries. 25. Initially, petitioner was appointed as a
Is it?
Gate 4 employee in contingency fund against the Lordships, petitioner was initially appointed against a leave vacancy for 1 month by an order dated by the respondent number 3. Then he continued his service in leave vacancy up to 1998.
Yes.
And he got lump sum amount, my lord, for the period of last 5-6 years. Then in 2001, Inspector School, Nalbari, forwarded letter to the director
Madam, we'll have it some other day.
Earlier, he approached this honorable court, lordship. Can you
Madam-
peruse this order
Madam
dated
Devi.
59? Yes, my lord.
We'll have it some other day.
Yes,
Get your facts
yes, sir.
in order.
Saturday, my lord,
get your-
Saturday?
Get your facts in order. We'll
Yeah, why not? Huh? Saturday, my lord?
The consent of the party is Saturday. No issues. I don't know. It's your department.
There are lots of advocates from his department.
Yes, at the consent of the learned counsel appearing for the parties, Raise this matter again on 7th of February.
Oblige, Your Lordships.
Your 7 তারিখে phone করে লাগবে।
Maybe, Lordship, kind of find the order dated 7/1/26, my lord. Last order, my lord.
Lordship, last chance was provided to the department.
No further time will
No
be
further time.
granted.
Lordship, in this case, Lordship, I have received one instruction, Lordship, just a few hours back.
Don't. Already additional affidavit was prepared and it was about to be filed on the last order.
On affidavit, they have filed, my lord. On affidavit, they have filed.
Lordship.
We are conversing with
My
him.
lord, sorry, my lord.
Allow us.
Sorry, my lord.
On the last order,
Lordship.
Ms. Terampi was about to file an affidavit on or before 21/2020.
But that affidavit
Could not be
filed.
without instruction.
Could not be filed, but one
Do not take an instruction today.
instruction has been received today.
It will be embarrassing for everybody. What is that instruction? What is the instruction? Tell
Lordship,
us.
may I read, Lordship? I have the honor, that the instruction received from Director of Secondary Education, that I have the honor to state that a letter received from the government, file number 1712 so and so, regarding furnishing the attendance of incumbent Rishi Kumar Upadhyay during the claim period of 2013 to 19, and also the result of the last 3 years, along with enrollment of 9th and 10th standard of the respective subject in respect of Borguri High Madrasa and Nagaon district for further examination of the matter. Therefore, Inspector of School was directed to submit original attendance register during those periods, Lordship. The Inspector of School Nagaon was asked to submit that original attendance register during the period 2013 to 2019.
What has the inspector done?
Lordship, that letter was
You
issued
will
on,
present him.
yes, that letter was issued on 21st of January 2026. That
Mr. Dotto, suppose you tell us, I had given to my clerk and he is not filing it. Will you make that statement in this court
No,
on
no.
any occasion whatsoever? Will I make a statement in this court that I had given a dictation? It has not come up, so therefore I'm not signing the judgment. Can I make that statement?
No, Lordship.
Can your director say that I have asked the inspector and he's not doing it?
That inspector reply, Lordship, is awaited, Lordship.
Has
I'll
the
come back
reply
with
and
that
come back?
reply, Lordship. Lordship,
4 o'clock.
any other day, Lordship.
4 o'clock.
Lordship,
They need a push. They need the push. I
Let me-
give another day.
let me try.
Then again on that day, what will happen? Another instruction will.
Let me try, Lordship.
And then we'll wait for another instruction. We are going to cut short the time period between the respondent and the court.
Lordship. Let me try,
We
Lordship.
are not concerned who is supposed to give you what.
Yes.
We are concerned if we have everything before us,
Sorry.
we proceed.
Lordship. Lordship.
After some
I'll-
time, when
after
you
some time.
get the information, tell
Okay.
us.
Lordship.
If the instruction is not available from the inspector's office, tell him to be prepared to take government duty tomorrow,
Lordship.
after some time.
May I please?
Yes, sir.
My lord, kindly see the last order, my lord. Yes, the last order, my lord, the respondents are directed to obtain instruction.
Marks regarding what?
My lord, Constable AB, my lord.
Yes, sir. Why not appointing him?
My lord. My lord, in this matter, we are yet to file a affidavit on the.
He says that the cutoff marks have been scored by him. And the score required the additional senior government advocate
My lord.
to apprise
Yes, my lord.
the marks received by the petitioner.
My lord,
We have it.
I don't have it, my lord. I have an instruction from the department, my lord,
Ah,
that they need further little more time
to find out what?
to send this
And what this court
marks.
has.
Yes. Note.
What we will do is, we will direct you to appoint him. Take all the time you want.
My lord, one thing, then my lord have to interfere in another case also. Of course, in the writ petition number 1902/25.
190, yes.
Similar situation arose, my lord, and this court gave a direction to, my lord, keep 200 posts vacant. In the meantime, state filed an IA. And my lord, on 9/10/25, the court modified it and court said, okay, fine, and keep 200 posts vacant and rest you can go ahead with the
Appointment.
appointment. We have gone ahead.
So,
So,
so if he has secured more than the cutoff marks,
yes.
someone who has secured
My lord,
less,
this is his, my lord, this is his stand that he has.
You are
We are
not-
yet to file our
you are
affidavit.
not replying to it.
Exactly, my lord.
Are
that-
you trying to impress upon the court that the respondents
My-
have
my-
the
my
right
lord,
to carry on asking for time to file
My lord,
affidavits or give instructions?
My lord, this is a matter of December 25. We are in 26.
So,
It's 2 months only, my lord. This is not very,
marks.
very, very
The
old.
marks.
My lord.
The marks of the candidate.
That is what, my lord.
Do you dispute the marks told by him? Where is your marks?
My lord, my marks, my lord, I have stated at paragraph 6, my lord, kindly, sir.
Is it page 37?
My lord, my paragraph 6,
Your marks
my lord.
towards the document. Would you like to be better prepared, sir?
My lord.
Would you like to be
37.
better prepared?
37, my lord.
Huh?
Page 37, yes, my lord.
Page 37?
Yes, my lord.
Yes, sir. The mark score is 20, mark score is 13.72. Passed in physical efficiency, passed in physical. Documents all given. And where is the cutoff mark? Where do we find the
My
cutoff
lord,
mark, sir?
cutoff mark, my lord, kindly see page 46, my lord.
What is this page 40?
My lord, page 40 is, my lord, admit card, my lord, for my lord, written test, my lord, paper 2, my lord. Thereafter, I appeared, my
Where is
lord.
the cutoff mark?
My lord,
Cutoff mark in your category, your district, your
my lord, yes, my lord.
category.
My lord, kindly see page 46. Dorong district, my lord. Unreserved category, my lord.
Just a minute. Dorong district, unreserved category is
Yes, my lord.
88.67.
88.67.
And what have you scored?
My lord, I have obtained, my lord,
13.72.
89.53, my lord.
24, huh?
89.53.
89.53. Where do we find the total marks you have obtained?
My lord, in the written test, my lord, I obtained, my lord, 34 mark, 37.
Where do we find that?
My lord, kindly see page 42, my lord. This is my lord, OMR sheet, my lord.
Yes.
42.
Huh?
My lord, 43 is, my lord, provisional answer key, my lord. After, my lord.
You have tallied it.
Yes, my lord.
After telling, you have got?
I have got 37, my lord.
37?
Yes, my lord.
And?
Out of 50.
Then?
Then, my lord, in the physical efficiency test, I got, my lord, 53.
No, distance of physical efficiency, you got 13.72.
No, my lord, physical efficiency test, my lord.
Yeah.
I got, my lord, 53.72, my lord.
How much did you score?
My lord,
Anything else? Any other score?
no, my lord. No.
So, oh. 90.72. That word comes to 90.72. 37, then 13, that makes it 50. And another 40. These are your documents. Who is the nodal officer, state level police recruitment board? Respondent number 5.
My lord, I received a letter from him only,
Yes.
that he is seeking 4 weeks time, my lord. That is
To
dated
do what?
31/26, my lord.
31/2026.
Yes, this is the letter, my lord.
It's February now. He's asking 4 weeks from 31.
One, my lord.
Give us a date when you can tell us the marks obtained by the petitioner, the cutoff marks, why the regret was shown, not selected, better luck next time.
My lord.
These 3 things have been asked by this court on 2 occasions
My lord.
in the form of instructions. Either the respondents do not have it or they are too busy to respond.
My lord, the thing is that exams are conducted in different districts.
Yes.
Then, my lord,
We will implead the nodal officer of that particular district if necessary. Tell us. Our intention is not to grant a relief or to reject a relief. It will be done after all the documents are before us. Our intention is when the court asks for an information,
my lord.
there will be situations where the information may take time. The reasons being appropriate, would we not consider?
I understand that.
Is it not?
My lord will fix the matter after 2 weeks. I will somehow extract the information, my lord, from them.
Heard, Mr.
In the meantime, my lord, one post may be vacant for the petitioner, my lord.
That
My lord,
was it.
now there is.
When was the select list published?
My lord, select list published in, my lord, in the month of October, my lord.
October 2025.
25.
And
And already, my lord, a ceremonial, my lord, appointment ceremony was done on, my lord.
see, you had the document of your marks before you.
My lord.
You had the cutoff marks with you.
Yes, sir.
You let October go. You let November go.
That I filed, my lord, RTI. That response also not given. That is why, my lord, I have. My lord,
You
let
filed
me-
an RTI to the State Public Information Officer when on the 1st of November.
My lord. Immediately after, my lord.
And on 21st of November, you were told no RTI.
Yes, my lord.
Heard, Mr.
Yes.
A. Hussain, Learned Counsel appearing for the petitioner. Also heard Mr. Aadhar, Learned Additional Senior Government Advocate appearing for the state respondents. Notice in this case was issued on 17/12/2025, requiring the respondent authorities apprise the court the stand with regard to the claim made by the petitioner in the present writ petition. The matter was thereafter fixed on 21/1/2026. On 21/1/2026, the Learned Additional Senior Government Advocate requested the court to have the matter listed day, that is on 4/2/2026, and the respondents were required to apprise the court with regard to the marks scored by the petitioner and to apprise with regard to the contention of the petitioner that although he had scored marks above the cutoff marks, he was not favored with an order of appointment. Mr. Aadhar, Learned Additional Senior Government Advocate, they submit that an instruction has been received from the respondent number 5, the extent that 4 more weeks would be required to furnish the information sought for by the court. This court notices that the marks obtained by the petitioner are available in the form of what? Where is that in the form of a preliminary document, no, in the form of a performance slip at page 37, within bracket annexure 7 to the writ petition. The cutoff marks as published by the respondent authorities is also available at page 46, annexure 14 of the writ petition, full stop. The information sought for by the court is with regard to records being maintained by the recruiting authority. Stop, this court sees no reason why the information has not been put. Mr. Aadhar, Learned Counsel, requests that the matter be taken up on. Yes, Mr. Dhar. Give us a date.
Well, 24th,
24th
February, my lord. My lord is giving us how much time?
Keep it sometime on the week between 16 to 21.
Then let it be 21, my lord.
Saturday.
Saturday. We are coming, my lord.
On 21st of February 2026. On which date? In the event the information sought for by this court is not made available through the learned additional senior government advocate, the officer holding the post of respondent number 5, namely the nodal officer, state level police recruitment board, Assam, Rehabari, Kamrup, Guwahati 8, shall depute a responsible officer to be present before this court along with the records relating to the selection process held for the district of Darang.
My lord.
For the district of Darang, which records should also contain the performance dossier of the petitioner hearing along with the records of the cutoff marks which was determined for the aforesaid district. Full stop. List again on
What about
21st of February.
not only district, because ultimately this is converted to state-wise, my lord. Exam conducted initially at the district level, then it was.
The performance would be assessed against a district.
Let us say, my lord, was a state list was made.
Okay, then you cut off. We have said that the nodal officer will depute a responsible officer along with the records, which will contain performance record of the petitioner in the district and also the cutoff marks as fixed for that district.
That district, my lord, because
Cutoff marks is district wise, sir. I'm sorry to say. Cutoff marks is secure district wise. So we are not saying that give me the records of Dorong. We are saying that how the cutoff marks of Dorong had been arrived at. That record should be there. Along with the state records regarding the cutoff marks, if any. 21st, either the records or the person concerned would have a would depute an officer to give us the records.
My lord, till then, my lord, one question may be taken, my lord. This direction.
The Learned Counsel for the petitioner has submitted that it was with the expectation that records should be duly produced before this court as required under the previous orders, that an explicit interim protection had not been granted to the petitioner. Full stop. The respondents are put to notice that in case this court finds that the petitioner has been subjected to non-selection despite having secured more marks and without there being any legal impediment thereto, it would be upon the respondents to provide for accommodating the petitioner in case he succeeds in the repetition.
Obvious.
Yes, sir.
Lord, the matter relates to Milord. Selection and appointment in the post of junior engineer civil in the Panchayat and Rural Development Department. Milord, pursuant to an advertisement, I being eligible and qualified to
in this case,
participate, Milord.
I have received the instruction, need to file an affidavit, Lordship.
Can we allow them the opportunity?
Yeah, absolutely, because Milord, only thing, Milord, is that our case is covered by a previous judgment. Now they are saying that we are fancier, Milord, so therefore that judgment is not applicable to us, Milord. In fact, Milord, admittedly,
Not only
Milord,
fancy, on the facts
Well,
also there is some
no,
distinct.
Milord, we have verified on the facts, Milord. I am similarly situated. I will try to make an attempt to satisfy my lord on that case, Milord. A short date, Milord, only difficulty is that only one post is lying vacant. So, Milord, in the
How
fourth,
many persons are there?
Milord, at present only one petitioner, Milord. So, Milord, if that post is
Another petition is also pending.
How many on the fence?
no, Milord.
Here only
it is-
one, another petition is also similar.
First fence, let us see what happens.
My lord,
Second fence, oh, they were fenced us. Let us see what happens to them.
my lord.
Yes.
My lord, only my humble prayer before my lord, Milord, if that post may not be filled up, Milord. A short date may
When was the selection process completed?
Lord, it was completed on
22.
the 22, Milord.
22.
My lord,
And you have approached this court in 25.
my lord, my lord,
They are entitled to 3 years for an affidavit.
my lord. Well, EWS
We'll
candidate-
grant them 3 weeks. We'll have it fixed after 3 weeks. 3 weeks of episode data, so 3 weeks hole ketia hobo?
তিনি সপ্তাহ লাগিব।
Process 25th?
No, the other file going away and replace it.
Huh? 11th of March. 11th of March.
Lordship.
Heard Mr. A.R. Bhuya, Learned Counsel appearing for the petitioner. Also heard Mr. P.P. Datta, Learned Counsel appearing for the respondents who have submitted that an affidavit in opposition has been prepared and would be filed shortly. Sir, place this matter on the 11th of March 2028. Instead, the respondents would be at liberty to file their affidavit in opposition on or before 24th of February 2026. With advance copy to the petitioner may file their rejoinder affidavit if any before the next date of listing. Full stop. The matter relates to selection and appointment. Full stop. Learned Counsel, sir, requested to be prepared for arguments on the next date fixed.
Lordship.
Learned Counsel for respondent number so-and-so, Mr. So-and-so appears for your name? It was appears on behalf of Mr. S. Datta, Learned, paying for the PNRD department. So he does not pay for any time to file his affidavit. It last line to লিখিব নালাগে. He does not pay to obtain instruction. Yes.
Obliged.
I've just collected the division bench order, Lordship, with 150 similar category candidate allow, Lordship, grade 4. That I just collected WN number 42. There's so many appeal, Lordship, 4-5 appeal.
Please, Your Lordship,
All are-
Lordship, the learned counsel appearing in this matter had to leave due to some family emergency.
Who?
The Upamandam.
They have filed affidavit yesterday.
They have filed their affidavit.
Yes.
You have got a judgment in your favor.
Yes,
At the
I think
request of the
this
learned
single
counsel
person
appearing
is
for the
the
respondent.
main, Lordship.
At the request of the learned counsel appearing for the respondents, the matter is passed over for the day. List it again on
Next week, any date.
20 February. 20 February 2026. Full stop. The learned counsel for the petitioner has submitted that the case will be covered by
Division
A
bench.
judgment of this court rendered in writ appeal number, give us one of the number,
428/2023.
8 of 2000. Learned counsel for the respondent is requested to come prepared on the next, to be prepared on the next day to submit on the judgment. Whether the judgment is applicable to the present case or not. Yes, sir.
In this case, I need to implete the new chairman of the Dhemaji Town Committee, my lord. So we need 6 weeks time, my lord, because the client is also not been able to come, my lord, because of his
Learned
ailment.
counsel for the petitioner has submitted that there has been a change in the office of the
Chairman office of the
chairman.
Chairman Dhemaji Town Committee.
First of all, we request that the matter will be taken up after
6 weeks, my lord.
and impediment petition is filed, full stop. Accordingly, list this petition along with the impediment petition proposed to be filed by the petition. We take it up as and when you file it. We come up as an I. We are not fixing a date.
Oblige.
Please, your lordship. Order has been complied, my lord.
Learned counsel appearing for the respective parties have submitted that the order of which violation had been alleged has been complied. Mr. So and so appears for your name
A.B. Datta on behalf of P.S. Rajan.
and
A.D. A.D.
DD,
A.D.
ED,
A.D.
AD,
Yes, fine.
not 2 days. AD. Mr. AD, learned counsel appearing for the respondents, full stop. Contempt petition is closed as complied.
Much obliged.
Yes.
Please, Your Honor. Your Honor, in this matter, the compliance order has been already done and there's nothing survived. So the contempt case may be closed.
Your name is?
A Kharbani, Miss A
Miss
Kharbani.
A. Kharbani, learned
Yeah.
counsel appearing on behalf of
T Chakraborty.
T. Chakraborty, learned counsel for the petitioner has submitted that in this case, the order has been complied with and there remains no violation as of today. Learned, Miss
And Burma.
appearing for the respondent number,
Both
for the
was-
sole respondent has submitted that
on behalf of
I
D.
has also agreed. Full
On
stop.
behalf of Mr. D.
On behalf of Mr.
D. Nat.
Nath has agreed to the aforesaid submission, full stop. Accordingly, contempt case is closed as complied.
But
My lord, in this case, my lord, department took several occasion time for filing a objection.
Yes.
Till that, they have not filed affidavit.
What is the subject matter? You see it also depends on the subject matter, how much time we can give.
My lord, last 18/12, my lord, they
Is it a T20? Is it a 1 day? Is it a test? See, what is the this thing? Subject matter?
my lord, in this case, petitioner seeking review, my lord, order dated.
Review?
Yes, my lord.
Where is the order? Of which you seek a review? Page 51.
Yes, my lord.
Yes, why do you want a review of this?
My lord, at that point of time, my lord, some facts are not, my lord, placed before this honorable court. Some facts are not placed before this honorable court, my lord.
How does it matter?
The petitioner working as assistant teacher, my lord, till 2017, my lord. Finally, my lord, page number 52, paragraph number 5, my lord.
Just a minute. There. The review maintainable. Where is the order dated 21/6?
$56, my lord, 21/6.
What do you want here? What is the order that, what is the part of the order that can be reviewed? Tell us. Which part of the order do you want a review of?
My lord, paragraph 10 and 11, my lord. 54, page number 54.
Okay. Why do you want a review of it?
My lord, in paragraph 11, that was reflected that 26/3 to
You
19.
really want a review of this order? You really go through the orders that you want review of? Read the first 3 lines of that order. Page 51. No, you are not reading the first line. Read the first line from page 51 for everybody to hear.
Heard assessed.
You sit before a bench without me. We are trying to cope up with work, sir. We cannot waste time like this. At least not because you have not gone through the file. Very sorry, very sad. Very sad. We are accommodating all that we can. Are we supposed to go through every petition to find out where, what is where? We are taking your submission for. I would have passed an order today. Yes. Tell us.
Contempt, my lord.
Contempt. Complied.
No, my lord. Actually, see, my lord, I have got some communication today. It has been sent to the finance department, the proposal, and then finance department has sent this for
Pensionary benefits, finance department. New trend. Is it?
Let the process be completed shortly.
How? Ms. P. Chakraborty, Learned Council appearing on behalf of the respondent number.
1, my lord. Actually, sir, one is not in office now. Pavitraram Khond is not in office. New incumbent has come.
No, but you are appearing for, you had an wakalatnama for respondent number 1. Appearing for the respondent number has submitted that although the respondent number Office of the Secretary, Department of Water Resources, however, she has received an instruction from the department.
Yes.
That the file is under process for compliance and the matter has been now referred to the ART and PPG department for their views. Full stop. It has not been reflected in the instruction as to when the file had been sent for views, full stop. Views of the ART and PPG department, full stop. The next date fixed. The Learned Council is requested to have information as to when was the file of the petition forwarded for the views as stated in the instruction dated 4th of April 2026. List again on when should we have it? When should we have it?
After 10-15 days, my lord, 2 weeks.
27th of February.
I'm being item 23 and 24.
You have 50 orders. Absolutely like you said. Okay. Huh? So for education. ডিসকাউন্ট শেষ কইল নাই ঠাকুরের সাড়ে সেটা বলি
27.
which is 27.
27. Yes. Lordship, that Inspector of School, Nagaon Lordship has submitted all required documents today, Lordship. The office received, Lordship. Just received, Lordship. So another sometime will be done.
What was sought for?
Lordship, short for the original attendance register for the period 2013 to 2019 and the result of last 3 years along with enrollment details of last 11 and 9 and 12, 10.
Administrators, AKSR learned. Also Mr. Kupi Patel learned council. The respondent still. A respondent secondary education. Mr. Doctor has submitted that department has received certain reports and records from the field officers, which would be necessary to formulate the response to petition. Accordingly, Mr. Dotto is afforded. Accordingly, the respondents are afforded time till 27th of February 2026 to file their response to the writ petition. List again on 27 to 2026.
Some observation may be given, my lord,
Regarding
affidavit, my lord. 7-1 is the last chance, my lord. That
He take some time, go outside the court, watch the replay. We have said something. We have made an observation regarding the affidavit.
my lord.
If it is not enough, come back. We'll add sentences. 36.
May it please, your Lordship, in this matter, we have we have filed our Vakarama today, my lord. Therefore, my lord, I seek some time to train my instructions.
What was the direction, sir?
WPC 726521, my lord. What are the dated?
Page 29, your lordship, there is a direction. Page 29 of the contents.
Kindly have the, when you file the affidavit, give us the dates on which you received a certified copy of the order and the dates on which they were processed. Appropriately processed, perhaps. Is it not? If it has been appropriately processed.
My lord. I'll obtain my instructions.
Who received it? Just a minute. When is the order of, when is the date of the order?
Office noted, your lordship, 30 January 2026, your lordship.
When is the order dated? When was the order passed?
Your lordship, it is 6/5/2024, your lordship.
And when did you give a copy?
Your lordship, we have served twice the notice, your lordship, just certificate copy.
So do you
Once
find-
no notice, receipt copy was given to us. Next time, the token number was given to us, your lordship.
Mr. A. Fupan, Learned Counsel submits that he has filed an wakalatnama for the respondent number
My lord, the director, full respondent.
for the sole respondent. List the matter again after 3 weeks on, list the matter again on, Coxon, March, second week, 9, 11, 13. 13th of March 2026, allowing the respondent to file their response to the contempt petition. Full stop.
Declared.
May I please, your lordship?
Yes, madam.
Lordship, this is a contempt petition for the non-compliance of the order dated 23/2025.
Let's come up for orders.
Yes, your lordship, on last occasion, the notice was issued. So the order, the matter pertains,
What happens after the notice is issued?
lordship, actually, they, as per the office note I have
Ah.
seen, they haven't received the AD card
So
yet.
we have to await the service report on the sole respondent,
Yes, your
one
lordship.
respondent.
Yes, your lordship.
Placed again on 24th of February to 25th of February. 25th of February 2026 for service report on the sole respondent.
Lordship, item number 38 to 40 are same, only
Okay.
the district and school is different.
No, we are asking whether the service is awaited.
Yes,
Office note says service is awaited. Or you have to see every order.
Lordship, I have to check. Can I?
Although this is item number 38, huh? Third
38.
miss.
A. Sharma.
A. Sharma, Learned Council appearing for the petitioner. Office note dated 28/1/2026 reflects that the AD card has been returned back from the sole respondent. Full stop. However, there is no appearance on her behalf today. Place this matter again on. What did you give the last one? 25 February, allowing the respondent number 1 to enter appearance. Same order. 38 লগত same order হ'ব, huh?
Okay.
Same order. 38, 39, 40, same order. Single order নহয়, same order. So what a বেলেগ বেলেগ.
Much obliged, Lordship.
Need please, our service report awaited 1 and 2 respondents.
Sir?
Respondents 1 and 2 service report awaited.
List again on 24th of February 2026, awaiting service report on the respondent number 1 and 2. Mr. P.K. Roy Chaudhary, Learned Council appears for the petitioners.
May it please, your lordship.
My
lord, may I kindly peruse the order which was passed on the last occasion on 21.
we have already released 5 months salary.
21/1/2026. There was a direction which was passed by this honorable court directing them to at least give an idea to the honorable court by what time they are going to release our salaries for which is pending for more than 11 months, my lord. We have a very basic case before your lordship that our salaries have been withdrawn instead of the fact that they have budgetary provisions and fund is lying in their custody, my lord.
They are
And
not
despite
paying.
of the fact that they are not releasing our salary for last 12 months, they are giving us in peanuts, my lord, 1 month, 2 months. And now my learned friend will submit to them, my lord, that 1 month he has paid.
Lordship, we have already paid 5 months AS.
No.
Lordship, kindly have a look. On 25/9/2025, we have released them 2 months salary. On 9/1/2026, we released them 2 months salary, and 30/1/26, we have released them 1 month salary, Lordship.
What is the order passed?
Lordship, and Lordship, there is a stay order is there, Lordship, not to disburse the amount. There is an order dated
Not to disburse the amount to whom?
to any other purpose.
No, he is getting wrong, my lord. Not to disburse the amount to any other purposes which the fund has been released to us.
That interim
That's
is
what
there.
they are wrong
There is-
interpreting
there
it,
is-
my
there
lord.
is-
No, the interim is there.
Interim is there.
Ambas.
Yes, my lord. But only humble submission, my lord. Let
Lordship,
them
we are
submit
going to release
by
the
what
salary
time they are going
step
to
by
submit,
step,
my lord.
Lordship.
I wish we had also had 2 volume buttons. We could
No,
make
Lordship.
1 0,
Lordship,
listen
they
to
have
him,
not-
make him 0, listen to you. Can we
Yes, my
hear
lord.
both of them, both of you
Together.
together? Seasoned advocates. Yes, sir.
No, my
What
lord.
is your prayer today?
My lord, today, my lord, only my respectful submission is there. On the last occasion, as this court has directed them to give us a rough idea by what date they can make release the payment. So my learned friend may submit, my lord.
Lordship, we have already released them 5 months salary.
When did you do so? When was it released?
On 25/9/2025, we released 2 months salary, and 9/1/2026,
in the month of January.
9/1/2026.
2 months.
Now, this order
and-
dated
and-
21/1/2026
Lordship.
is after 9/1. Tell us
Lordship.
after 9/1, sir.
Lordship, on 18/12, what happened? We stated that we release 1 month salary, current salary, but we have released 2 months salary to them, Lordship.
Salary of all other persons.
All employees, not only.
Salary of the persons who the disbursing authority is sitting there. First, we stop that.
No, Lordship.
His allowances, his petrol allowances, his electricity bill, water bill, all
So
stop.
we are going to release them by.
We are doing it today.
Some time because
Why?
they have not taken the VS option because they.
Why should they? It's an
That's the
option.
cabinet decision that
It is an option.
earlier, Lordship, we paid the salaries to the employees from our own source, Lordship.
So now just tell us this much, sir. They did not take the VRS. They are under a writ petition. They are challenging something. They are doing something. Fund is there in your account. You have your liabilities to the whole world. Assuming all this money is supposed to be paid somewhere. How many people are not being paid? Okay, at least one information you can give us tomorrow. For the month of January, salary for the month of December and January, disbursed in January and February. Which of the employees have been paid salary and allowances? To what extent? And which of the employees have remained unpaid in the board? If it is grade 2 and above, salary has been paid. Oh, yes.
We have not paid salary to.
To yourself also.
No.
To yourself also. No, I'm not talking to the council. I'm talking to the person handling the money matters in the board. Has he been paid his salary? Are the officers getting salary?
No, Lordship.
Nobody has drawn salary.
No, nobody has.
Give us that report in December that nobody has drawn any salary for the month of November, December, January. We will reject their prayer for interim payment as of tomorrow. Any salary paid to any person.
136 employees there, Lordship.
How many have drawn salaries is what we are asking you. Can that not be told to us?
I have to take instruction on that. Because
Tomorrow.
Can it be on it?
It's accounts, money on fingertips. Everybody has it on fingertips.
But the money is not only for the salary head, Lordship.
I have not asked you about how much money you have. I have asked you who are the employees who are drawing salaries and who are the employees who are not drawing salaries. Plain and simple. Tell us that.
Lordship, my learned friend saying that we have the money, Lordship. Have a look the.
We are not convinced. We reject him. Yes, Mr. Borgohain, there is no money in the
Our
fund.
requirement is requirement.
They are rejecting you.
Lordship, have a look at the requirement.
We have rejected.
How much amount we
I
have
just
received from
want
the
to
government?
know September, now we'll go month-wise back. We started with January.
Yes.
Now we go earlier we went to December. Now we are going to September. September, October, November, December, January. Which employees have received salary and which have not?
Correct.
When can you give us that? Simple. We are not granting them an interim, sir. We are rejecting their pay for salaries as of today. We are not passing an order. No orders for salary. Tell us.
On Monday, Lordship.
Monday.
Monday or Tuesday.
Tuesday will be, Monday will be fine.
Eh?
Monday will be fine, madam.
Heard Mr. H. Burgman, Learned Council appearing for the petitioner. Applicant also heard Mr. Handbora, Learned Council appearing for the
Appearing for the.
NJ Gogoi, Learned Council appearing for the respondent authorities in the interlocutory application. Full stop. By the order dated Seventeen 11/2025. The Learned Standing Council for the ASAMB was given the liberty to obtain instructions by the order dated 21/11/2025. The amount earmarked for arrears salary was directed not to be disbursed for any other person without leave of the court. The respondents had not yet furnished instructions to the
So we have filed
Learned Council, huh?
In this regard, we have filed affidavit.
In the IA.
In the IA.
In the
Filed
IA.
affidavit.
I'm recording what is there in the orders.
Lordship.
On 3/12/2025, the Learned Council, Standing Council, ASAMB and the Agricultural Department respectively were required to obtain instructions regarding the implementation and status of the cabinet decision relating to the closure or winding up of the Assam State Agriculture Marketing Board and the fate of the 136 employees, including the present writ petitioner who claim to be employed, full stop. By the order dated 10/12/2025, this is not to instill fear on you. This is for us to remember on the next date. We don't have to read through each of the orders. Yes. By the order dated 10/12/2025, the submission of the learned counsel for the petitioner that salaries for the past 12 months had not been released had been recorded, directing the respondents to apprise the court through the learned standing counsel for the board as to what steps the board intends to take for release of arrears salary and current salary to the writ petitioners who claimed to be working without salaries for the past 12 months. By the order dated 8/12/2025, this court required the learned standing counsel, recorded the submission of the learned standing counsel that an affidavit has been filed, wherein it was stated that the current salary of the petitioner will be released on the first week of January 2026.
We have released us.
That related to the period of service for December 2025. You'll pay in January when? For the service rendered in December 2025. 1 month salary.
No, we released on 9/1 lawsuit, 2 months salary.
2 months salary. Okay, 2 months salary.
2
had
months
been
salary already
released
released
on one.
as per
On
order
1/1,
dated 18/12.
2026, yes.
18/12.
And
And last lawsuit on 31, we have released 1 month salary.
by the order dated 21/1/2026, this court had again requested the learned counsel for the respondents to apprise this court as to the period within which the arrears salaries for the petitioners shall be released by the respondents, more particularly the marketing board. Full stop. Interim orders passed earlier restraining disbursal
Not
for
right.
any other purpose was continued. Full stop. Today, Mr. N.J. Gogoi, learned counsel appearing for the state respondents, has submitted that.
On 31/22, we released 1 month salary.
By when will you release the arrear was the question? Answer that question, sir.
Area is lawsuit, sometime is required lawsuit.
That some time would be required.
We
release the area
arrange
salaries of the petition.
arrange salary from our own source lawsuit.
They are, since the marketing board is arranging for salaries from their own source.
source.
Full stop.
We have
On the
already
next
stated in
date-
my affidavit.
On the next date fixed, the learned counsel for the respondents shall produce before this court appropriate instructions from the respondents as to the salary which has been disbursed to each of the employee of the respondent marketing board on and from 31st of March 2025, and the list of the employees who have not been given their salaries after March 2025, after 31st of March 2025. Full stop. The list should contain the designation name of each of the persons who has drawn salary on and after 31st of March 2025, along with the amount of salary, allowances, etc. drawn by, if any, full stop. The list will be produced before this court on, give us a date, sir.
Then lawsuit some time is required because we have to prepare all these things from
You
the.
don't even know who is drawing salary and who is not. Can that be? One tab of a computer.
From
is
12
one
from
click.
12th of March.
12th of?
March, 12th of February, sorry.
Oh, we were giving you more than that.
Then lawsuit. Yeah, then another.
We were giving you more than that. Choose something between 16 and 21.
On 21 lawsuit.
So
21 is otherwise a Saturday. Why not?
Otherwise-
We are working third Saturdays.
Pretty much not.
We'll allow a VC.
No, I'll come, of
21st.
course. I'll come, of course, my lord.
Huh?
21st.
He has difficulties on 21.
No, I can come, my lord.
No difficulty.
No, no
21st.
problem.
21st of February.
21st of February, my lord.
Yes, with the consent of both the parties.
Oblige this.
Go on. February. I'm obliged, my lord. Deeply obliged.
Hey, civil.
Please, your lordship.
Yes, sir.
This is an application for striking out the new accountant general because here prayer is that regarding challenging of the special order. We do not have role in this regarding.
You are challenging a judicial order.
I am the petitioner, my lord,
Uh-huh.
but I have not been
Special
served
order.
with any copy of my lord, any IA till date, my lord.
You want the name of whom to be?
8. That is
AG.
just accountant general any Assam. Presently do not have role in this case.
Then you are praying for what?
I am entitled for a copy at least.
No, you are praying for what in the writ petition? Just for
Termination from service, my lord.
You are terminating.
My entire, my lord, service benefits and everything, my lord, that will
Now,
be taken
if
into
we allow the
consideration.
writ petition,
My lord.
where does the AG fit in? Accountant General, where does he fit in?
If
He
my
would
lord,
be releasing your salaries, or he would be giving
compulsory
the-
retirement is allowed, or my lord, there may be any possibility outcome of the writ petition, my lord. Under that circumstances, because the AG will decide finally, my lord, my pensionary benefits and all, my lord.
They're required to be a party now. Sir,
I,
give me a copy,
because
sir.
I don't know.
Yes, yes,
what
right,
is-
right.
Sir, give me a copy.
We'll
Have
just
the,
definitely later.
what about the writ petition? Affidavits have been exchanged by the other respondents.
My lordship, some affidavits have been filed, my lord.
Any more affidavits required?
Yes, my lord.
From whom?
Home filed, my lord.
Your services were terminated by whom?
Home, my lord.
Then the home has filed an affidavit.
My lord.
If you have filed your reply,
My lord.
perhaps you can take up the matter for disposal on a particular
My
day.
lordship. Lordship. Only, my
And we
lord.
will record your submission that you are not a necessary party as per the IA.
Presently.
Therefore, you are exempted from filing an affidavit in opposition in the writ petition.
Definitely.
For the present, that
Yes.
will do.
Yes,
My lord.
Heard Mr. C. Burra, Learned Counsel, appearing for the applicant,
Applicant.
oblique,
Respond number 8.
Accountant General,
Any Assam.
any Assam, who also has been arrayed, which respondent has been arrayed, which department has been arrayed as the respondent number?
8.
8 indeed in WPC number 6937 of 2024. Learned Counsel appearing for the Accountant General within bracket A and E, Assam, has submitted that they are not a necessary party in the writ petition. Therefore, praise for striking out the name. Learned Counsel for the petitioner, Mr. So-and-so has submitted that copy of the IA has not been served upon him, and therefore he cannot answer to the assertions made, full stop. Taking note of the submissions made, it is provided that the Learned Counsel for the applicant shall serve a copy of the IA on the Learned Counsel for the petitioner, full stop. However, since the applicant has submitted that they are not necessary parties to answer anything, answer the assertions in the writ petition, comma, they are exempted from filing an affidavit in opposition for the present
Not required.
till the next date. Yes.
Necessary.
Now we said that you are
Yes.
exempted, we said. Since you
Yes.
submitted it is not necessary, you are exempted from filing an affidavit in
Fine.
opposition.
That's.
That will solve the problem? Yes.
We'll go
Any date fixed on
Actually,
the
with the
writ petition?
department once.
No dates are fixed.
No, my lord,
You.
one date may be given, my lord. And in the meantime,
Huh? Hmm. When can you complete the pleadings? Have you filed your reply?
my lordship.
The reply, you have filed the reply to the affidavit opposition. Is the matter ready for adjudication?
Lord, one thing can be done, may I suggest, if my lordship allows me. In the meantime, my lord, matter may be fixed for final.
The in the writ petition takedown, Learned Counsel for the petitioner submitted that he may be allowed to file replies to the affidavit in opposition filed by the respondents, full stop. Allowing the same, list this matter again on a list again after the reply by the petitioner is received.
Lord, may I pray for a
File it
day,
tomorrow, it will come up day after tomorrow.
my lordship?
File your reply tomorrow, it will come up day after tomorrow.
My
I
lord,
have said file on receiving the reply from you.
my lordship,
File it as soon as possible, it will come up as soon as possible.
my lordship.
Delay it, it will be delayed.
Yes, sir. Deeply obliged.
Any departmental proceedings, sir?
Lordship, everything concluded, right up to rejection of appeal.
No, the co-conspirators.
Or others, they are supposed to take instruction, Lordship.
That was the instruction required.
My lord, we got one instruction, my lord.
Which says that the other co-conspirators have conspired against him. No, that was the answer. We could have closed the writ.
Two of the co-accused, my lord, one is removed and one's DP is still pending.
Yes, they have DPs against them. So that part of the argument we can.
That can be, it can be decided independently of.
Independently,
I
yes.
have to decide on my own merit, Lordship.
Okay. Where is
Lordship, one
the,
thing is important,
where is
Lordship.
the second show cause notice?
Lordship, one thing is important, Lordship.
Huh?
Among the list of document, Lordship,
Huh?
that the complaint on the basis of which the trap was laid, that is not part of a listed document.
We need that.
What
To
happened,
decide a
Lordship?
discipline
No,
proceeding?
what happened, Lordship, in this, a person lodged a complaint that my relatives are lodged up, and when I approached them, the name was made of two SI and Mukunda Upadhyaya and one Lordship Hirakjyoti Deka. My name was not named in that
Do you have
complaint.
a copy of the second show cause notice?
Yes, Lordship.
Where is it?
Lordship, my ground is that every witness parroted the same thing. That is
Yes,
the
we will go into that also. Kindly show us the second show cause notice.
Lordship.
Your assisting counsel would do better if she was keeping a track.
Lordship.
Yes. Just argue that.
Second show cause page 36.
Please read it.
You are hereby informed that inquiry and so on, so on, so you have a copy of the final on perusal of final notice, gross misconduct in discipline act and dereliction of duty are proved.
This is prior to giving you the inquiry report.
Yes, Lord.
Let us close it. Should we close it? Finished. Do
Lord-
we need to go anything
No,
else?
Lordship, there's predetermined.
Yesterday, there was one judgment from this court.
Lordship.
2026, 2025, there
I
are two or
think that-
three judgments in this court. That is why I said your assisting counsel would do better if Saturdays, if not first and third Saturdays, if not attending court. We will give it a research work. Ask her to find out those judgments. Second
This-
show cause notice
This Saturday, Lordship,
is one part. Then
predetermined, that is. One of the,
predetermined is when the second show cause notice. appears.
Justice B.K. Sharma's judgment is also there, one of the judgment also.
Talking of recent judgments, we are talking of yesterday.
Lordship.
We are talking of a few days before that.
Lordship.
That is something I don't think Mr. Kaur has filed an appeal against. List on Friday
My lord,
or list on 7th.
Saturday, Lordship.
Honorable Justice A.K. Goswami, there was the judgment initially. Then Justice S.K. Methi. Then few other judgments, my lord.
Yes.
Saturday, Lordship. Oblige.
Saturday, 7 তারিখে দিও। এগুলো judgment আমার dictation
Lordship,
করে বলে
that-
7 তারিখে use to
Can it be part heard?
Saturday it is coming for us. No? If the benches are not rotated, because we have been only asked to fix cases on Saturdays, where
Which can be
on this Saturday at least, I am fixing cases
Which can be disposed.
where there where the consent is there. We don't want to disturb anybody on day one. It will be last meeting.
No, sir, I think the records will be required because the affidavit that we have filed based on a CID PS case, was show cause notice was been given. After
Where
the
is the
court-
show cause notice?
Not affects this or affidavit in.
You don't have the. no,
That's
they-
why I am.
They would have
praying for-
given.
Our show cause notice will be in the record. Sokos, copy of the Sokos notice will be in the record.
Annexure 6 in the read petition, page 40.
Annexure 6.
Yes,
Have you flag marked it here? No.
no,
Tell us the page number.
page 40. Page 40.
Page 40.
40.
Then Lordship DP started.
Then the DP started. You did not reply, then you had made a lot of.
Then inquiry
Then what
officer
happened?
finding of allegation
Then
of
there is a. Take second. Second show cause notice.
Yes.
Hmm.
In the
Page
first,
53.
yes, sir. In the first show cause notice, madam, list of documents, there are 3 documents, but they relate 68 documents without giving me any copy. Madam.
You are not required to be given copies.
Let,
You are required to ask for inspection.
inspection, but no chance was given, my lord.
Did you ask for it?
Yes, my lord. Because, my lord, your lordship kindly see the page 42, my lord.
Page 40?
42.
Ah.
List of documents to be
When
exhibited.
you show us your application that you requested to be
Yes.
given the copies of the documents.
Yes, my lord. Page 46.
Page 46.
6. Yes, my lord.
Oh, a long request.
This is also my grievance, my lord. Page 46 to page 47, all my representation, my lord, on different issue for defense witness for.
If
And I
you,
was
if
totally
you, if you,
unaware.
if you make us read the entire representation on your behalf,
Yes, my lord.
most of the time we will be preparing the case sitting in the court.
Yes, my lord.
We need the assistance so that you can tell us page 48, point number 8, page 49, point number 9. Tell us which sentence you have said, sir, please allow me to inspect before you start the department. Against me.
Yes, my lord. Annexure 11, page 40. My lord.
Annexure
11, page
7.
50.
Ah,
In inviting reference to the subject, I have the honor to state that the stage of hearing of witnesses in connection with so and so DP are completed by the
no,
inquiry.
you have asked for statement of the
Yeah,
witnesses.
next line. Without proper cross-examining from my side, the inquiry officer fixed for recording my statement along with my defense witnesses. Previously also, the list of documents which are mentioned in show cause notice was issued to me, but this time I humbly request you to provide me the copies of statement of witnesses, which are very much important in my defense. Therefore, I kindly request you to provide the required statement of all the witnesses and for which I can prepare my statement as well as
If
my
you want
defense
us to
witnesses.
read the letters page wise, or if you deem it proper that you should read the entire document here in the court to us, I think we should have to take a day where we will have some more time, sir, not at 4:20 in the afternoon. We don't have the time. We'll simply keep reading documents.
Any other date, my lord.
Give us a date. Tell us a date.
Next week, my lord.
Tell us a date. Next week.
Yes.
Not possible.
Or Saturday, my lord.
No, not on Saturday.
Why not? Why not? Whatever was done on Fridays will now be done on Saturdays. On and off duty hours. Yes. We will have it on the 11th of March, 2026.
Yes, my lord.
Yes? 11th of March, 2026.
In the meantime, I'll get the records.
The pleadings in the matter are complete and the matter was listed for hearing. Full stop. However, paucity of time does not allow the matter to be taken up for disposal. Full stop. List this matter again on the 11th of March. 11th of March? No, 11th of March? No, 10th of March. On a Thursday, 10th of March, 2026, on which day the learned counsel for the respondents shall be prepared with the records of the disciplinary proceeding involved, and the matter would, an attempt would be made to dispose of the matter. List again in the hearing column.
Whatever.
Huh? 47.
Made, please, your lordship.
Hmm.
And this
It
case,
is
your lordship,
dischargeable
led by
on
Mr.
October
K.
7.
Chaudhary.
Huh?
Your lordship may kindly be pleased to fix a date, your lordship, and adjourn the matter for the day.
At the request of Mr. T. Deory, learned counsel appearing for the petitioner. List the matter again on, sir, Tuesday.
19th, your lordship, if you.
19th of
19th
February.
February, your lordship.
2026. Inquiry proceedings.
Yes, your lordship.
2026. Full stop. Pleadings have been stated to be completed.
Yes, your lordship.
And the matter is ready for hearing. Accordingly, list again in the hearing column. Yes,
May I please, your lordship?
I think we'll have to give one more opportunity. Or can find out if there's someone from the education department. What is the order? Order? My order of which violation is
It is in page number 14, lordship.
page number
14.
40.
14.
1-4. It starts at 1-4.
Yes, lord.
What part has been violated? The order dated 31/2026 reports that there was no representation on behalf of the sole respondent, full stop, sole respondent. Just again on. Ninth of March, 2026, allowing the sole appearance in the make clear and
Yes.
53 কি করলাম হ্যাঁ কেটা আছে ওটা দিয়ে বলে
In this case, I'm appealing for respondent 1, 2, and 3. 2 weeks time may be given for finding reply, but in a place.
The learned counsel appearing for the respondent authorities have paid for 2 weeks' time. File their response to the same, to the repetition, full stop. Is noticed. Full stop. The interim order passed earlier shall continue. Respondents shall ensure filing of affidavits on or before the next date of listing, that is on. The data did you take? 3 weeks. I said 3 weeks. How much time did I say? 2 weeks. I thought I did 3 weeks actually. Yes. 27th of February 2026.
Deeply advised.
Mr. Dutta, there is a contempt petition we have fixed on. There is a contempt petition which we have fixed in March, 1 or 2 items before that. The director has been served. None is appearing on the last date. None is appearing today. 2 items before this. 2 or 3 items before this. Keep a track. Adverse orders would follow.